May I be permitted to mention a matter, my lord, for inclusion in the list
Please come on Monday.
as motion, my lord.
Monday. Mentioning on Monday, please.
My lord, item 90, my lord, the urgency is, my lord, pre-deposit in the appeal. Tomorrow is the date for contempt.
Let me see.
My lord, tomorrow is the date for contempt. Your lordship kept the matter today, my lord, for the pre-deposit. We did the deposit yesterday. My lord, the matter is returnable tomorrow, my
See
lord.
how far I can proceed. Yes.
My lord, it's not on caveat, my lord.
Only one prayer. Item number 86, my lord, I mentioned twice. Lordship, my lord, said to wait. My lord, 37 is a similar matter by another petitioner, my lord. If it can
Let me see how far I can reach. Yes.
come at 37, if this can
My lord, my contempt is tomorrow, my lord. Your lordship kept this matter today.
Yes. Call the list.
My lord, kindly, my lord.
Lord, item number one.
I am filing the death certificate up to the point section. I have different statutory. That yesterday my order of stay was refused on the ground.
All right, leave granted.
All right, I am the relief. I am filing the death certificate of the hospital and rural certificate. I am for leave for filing the.
All right.
Item number 151, Lord, my son's birthday. Your lordship
Mr.
directed me to
Mukherjee,
start.
please wait.
Lord, my son's birthday is on Saturday.
Yes. Let me see.
My lord,
All right.
I'm sorry. my lord.
If all of you want to mention for upgradation, it's difficult.
Extension upgradation, my lord. My lord, extension upgradation. My lord, today, in a peculiar circumstances, I am.
What is your item number, Mr. Nag?
It's not in the list.
Please wait. Let me see how far.
Today the matter, my lord, except, my lord, a section 9 order has been passed. My lord, I am challenging that. My lord, on the basis of that, a writ petition has been filed before, my lord, in the residual. Now, my lord, today the matter is coming. So, my lord, I am supposed to complete hearing before that. So, my lord, any date fixed, my lord, so that I can convey to the court
Yes.
number 25 that the matter will be taken up. This is the order, my lord. I have annexed.
Yes.
My lord,
And what's-
extension of interim order, my lord, expire on 20.
Extension of interim order, please hand over the slip. Yes, call the list. Yes.
Only,
Nearly.
may I move it today? Not it's possible. Is it?
Today is not possible. Yes. Who is appearing in this matter?
Actually, director has to serve Miller on the mother who appears in person. Miller, we served her by mail because we don't know where she is.
Why the address is there?
Yes, the address, but it was only given to us on Monday. The order was passed on Monday.
Strategy.
No, without her, Miller, I don't want to Miller proceed at all because
Please serve by post. I'm keeping it in the next week. Please tell me when the service will be completed.
today, Miller, is Wednesday. Keeps it on Monday. And also directs us to serve by hand because Miller, my client and the
Mr. Chatterjee, learned advocate.
then it's fine. Because Fateh Dua's Daha Miller, it should be put in your lordship's calendar as to be notified.
All right, list this matter
That's the
27th.
provision that told me, Miller, I had no clue.
27th, under the same heading. Yes,
Great.
next.
I am for the opposite party.
I am for the petition, my lord.
Yes.
The matter is relating to the, my lord, concurrent finding, my lord. We have lose the case, my lord. Subsequently, this CEO.
Oh, this
civil
is that
division-
matter.
Yes.
Friday. Friday, I'm fixing.
Friday?
This Friday.
Lordship can hear it now. Lordship can dispose of it. There's nothing in the matter. Nothing in the matter. Concurrent finding of both the courts.
It has to be hard, Mr. Rai. You may say concurrent finding. Concurrent finding is not required to be hard, Mr. Rai.
That's true, my lord.
Then I'm keeping it this Friday.
This Friday.
Yes. list this matter on next.
Item number 3, my lord, I am appealing for the petition. There is a small correction, my lord. In the order, my lord, at page 2,
Yes,
my lord, it has been stated that the learned civil judge junior division first court at Birbhum, it would be first court at Bolpur, comma Birbhum, my lord.
Learned Civil Judge Junior Division, first court at Bolpur
Bolpur.
district. It has been pointed out that in yes. কি আছে?
The other side has mentioned the matter for correction in the order.
It has been pointed out that
Well, the CO number is appearing wrongly.
Yes,
as
yes.
Two places of the order.
Uh,
At the first page, then at the last page.
so 2161 should be disposed of.
Yes, 216.
It has been
Yes, yes.
yes.
My lord, item number 7, my lord, I'm praying for extension of interim order, my lord. Let a date be fixed, my lord.
Have you served upon the other side?
Informed, my lord. We have informed, my lord. We have informed, my lord.
When have you informed? Who is for the other side? Please bring in, pass over. Yes. Call the next matter.
I am for the petitioner, my lord.
My lord,
Kindly,
I'm for the opposite party, my lord.
in page 6, my lord, stay order granted, my lord, kindly.
After hearing the learned advocate for the petition, please serve. Then,
My lord, kindly keep this matter next week for the final hearing, my lord.
tomorrow, yes, tomorrow under the extension of interim order. Yes, call the next matter.
Lord, this is that matter, my lord, your lordship wanted us to serve the borrower, the Salt Lake property, my lord, where admittedly, my lord, there are 3 heirs. 2 heirs said that they are the only heirs. And my lord,
Yes,
so we have served upon the borrower, my lord, if.
service is completed.
Yes, my lord.
But I think
When they have received,
learned friend is appearing, the borrower
you are appearing for the borrower. Respondent, yes,
Lord,
But we have our affidavit, David, the affidavit of service, my lord, may be kept on.
he is appearing.
Now, admittedly, my lord, there were 3 heirs. The other brothers and the mother, they said that they were the only heirs, and my lord, mortgaged the property with Mr. Kaur's client. Now, the problem that has arisen here, my lord, is that my right with respect to that property, my lord, is not partitioned. The DRT said that you can't go ahead without demarcation of my right. The DRAT said that you can go ahead with the demarcation as well. In the sense, my lord, you can go ahead with.
How long you will take, Mr. Chatterjee? All of
take
you,
about an hour.
about an hour.
Yes, yes, there's a lot of question of law involved here, my lord. It's not
but
because
I
the
had
learned senior
I had given an
has taken
undertaking
up the
that,
point.
Lord, I will not try and take possession in the meantime, because your lordship had fixed the matter on 17th, Lord, at 3:30.
Yes, till 19th, this undertaking was there.
Now, Lord, if the matter is taken up for final hearing, I have no objection. Lord, your lordship can hear it. Lord, now that the borrower is there, Lord, the undertaking, they will have to explain why they had given an undertaking which is not in terms of the
Yes.
inherit.
Sir, I am not dependent upon their undertaking. I am on my own right.
We'll see that.
Yes,
Lord, we'll
yes,
see that.
certainly, absolutely. Because my learned senior friend has taken up a point of section 44 as well. So I'll need to, my lord, counter that as well.
So,
Whenever your lordship.
can all of you come at 3:30 PM today? Why?
Anytime in the morning, my lord, whenever your lordship pleases.
Mr. Chatterjee, it will, the entire list will be stalled. Any day in the afternoon, on
Next
which day?
Thursday? Next Thursday in the afternoon?
Next Thursday means Thursday week.
Next Thursday is Thursday.
Today's Wednesday.
Thursday. Today is Wednesday.
Yes.
We can come tomorrow. There is no
Tomorrow,
Lordship fixes it. I have no problem. Fixes it. If I'm in difficulty, my lord, I'll let you
tomorrow,
know. Tomorrow. Fixes it. I have no problem.
you are in difficulty.
He is in difficulty all the time and genuine. I'm not saying.
No, I don't think it's genuine.
No, he. I'm talking about him.
We will not be available after 3.
My lord, some loudspeaker somewhere needs to be brought down.
What time will be? Monday, in the second half, at that point,
I'm always before you.
Monday, you don't have any problem.
And I don't have any problem anytime.
Please file the, leave is granted to the learned at undertaking, Mr. Yes. Who is appearing in item number 10? Yes, yes, please start. Yes, there's an appellate remedy. In view of the alternative and efficacious
I appear on behalf of the petitioner plaintiffs.
Yes.
My lord, suit for declaration that defendant number 1 to 3 are having no right title and interest over the suit schedule property, are trying to interfere with my peaceful possession, injunction against them, and partition suit.
Where is the plaint?
Plaint is at page number, my lord, page 41 onwards.
41.
Yes,
Where is the prayer?
Prayer, my lord. There is at page number. My lord, 49, 40, 48, 49, 49, my lord. My lord, Badigoner Prathana.
Where is the written statement?
A written statement thereafter, my lord, page number 53. Wrongly written as 1 to 4, it should have been 1 to 3.
Yes. Then what happened?
My lord, I filed this revisional application by challenging the reference which the learned trial court has made at the stage of argument under section 18(1) or read with section 21(3) of West Bengal
There's a
land.
claim of Borgadar.
Yes, my lord.
Then
My lord,
it has to be referred.
my lord, the reference is bad, my lord. The reference is bad as well as time barred.
Why?
My lord, the written statement, the defendant number 1 to 3 has categorically pleaded but they have taken the defense of co-borgadarship, which is not recognized under the law in terms of
That
section
cannot be
15A.
decided here.
My lord, my lord,
Make that submission.
One thing. My lord, thereafter, my lord, they have admitted the sale which took place in the year 2007 and 2010. My lord, as per 18(1) proviso clause, the limitation is 3 years from the date of knowledge, my lord. They have not stated that they were not aware about the sale date. They have pleaded that this entire sale is a collusion, has been taken effect in collusion with the original owner. My lord, kindly take up 18(1) of proviso. My lord, the reference, there are 3 kind of reference stated in section 18(1). My lord, one is division. If there is any issue regarding division or delivery of the produce which is absent, my lord, recovery of produce under section 16A and termination of cultivation by the Borgadar. These are the 3 references. My lord, kindly take up the proviso clause, provided that no application for decision of any dispute shall be entertained unless such application is presented to the officer or authority.
Mr. Nayak, please kindly come to section 21, subsection 3.
Yes, my lord.
So reference is under that.
Yes, my lord. Read with section 18(1). My lord, kindly see.
By the authority, not read with. By the authority mentioned in subsection 1 of section 18. For reference authority, it has been referred to 18(1). This application under Article 227 of the Constitution of
just a mere plea, my lord, by mere pleading, my lord, the reference has been made. My entire, my lord, powers, my lord, no single document has been produced, my lord. Kindly see, I have annexed the entire evidence, documentary, oral evidence as well as documentary evidence. But the fact of Borgadar is the fact which is to be proved by a way of document, not by oral evidence or oral assertion, my lord. But kindly take this aspect into consideration, my lord, without any prima facie evidence. At
Mr. Naik,
argument-
that cannot be decided here. Please show me that there has to be a prima facie case made out. If you have, that question arises, it has to go.
Question arises, that has to be some basis, my lord, or subject to correction, my lord. Subject to correction, there has to be some basis.
Have you considered the judgments on section 21(3)? Have you considered any of the judgments? Have you considered? Yes, what does that say? Please show me those judgments. According to you, defendant numbers 1 to 3 are your co-sharers.
Yes, they are my brothers, but they were not, my lord, in terms of section 15A, my lord, only one person shall be nominated as Borgadar. My grandfather, my lord, may I please the fact, my lord, can you take me, hear me for a moment, my lord. My lord, Dharonidhar Mondal was the original riot of over the
Where are the issues framed? Please show me.
issues.
Yes.
My lord, perhaps the issues has not been annexed. My lord, I have annexed the entire evidence. My lord, may I place, my lord? My lord, our case is that Dharonidhar Mondal was the original riot. My lord, thereafter Horipada Mondal was appointed. He is our lineal ancestor, my lord, Horipada Mondal, common ancestor. And thereafter Horipada Mondal expired. And
Mr. Naik, why have you implemented defendant numbers 1, 2, and 3?
my lord,
According to you, they do not have any right, title, and interest.
yes.
So why have you implemented them in a suit for partition?
My lord, my lord, claim of partition is against defendant number 4 to 14.
So can you include someone who is not your co-sharer in a suit for partition?
It is not entirely coupled with another relief as well. Declaration against the defendant number 1 and 2 having no right of interest over the suitable property.
Thank
and
you.
they are trying to
Ashok,
interfere, my lord.
this suit cannot proceed unless that is decided. You yourself has created this problem by making that seeking that declaration in a suit for partition.
They are claiming from common ancestor, my lord. They are not disputing.
That can be decided by the civil court. Has to be decided there. Raise all points there. It will be open to the court. It is however made clear that it will be open to the petitioner to raise
Lordship, the husband is the petitioner before your lordship. By the order impugned, lordship, section 24 was allowed, directing the husband to pay 23,000 rupees per month to the wife. Only wife, lordship, no children.
23,000, Mr. Chakraborty, is the nominal amount.
Lordship, the learned trial judge has come to a conclusion that the husband.
What is the income of the husband?
50,000 per month.
50,000.
Yes. And 23,000 has been awarded to the wife. Lordship kindly comes to the order impugned. That is at after part 2, lordship. Lordship will kindly come to the second last page, lordship, of the order impugned, paragraph 18.
Chakraborty, is very difficult to believe that with the passage of time, year to year, your income is decreased. The income.
Explain. No, lordship. First, I was, lordship, working in a private company. I have mentioned.
Assessment year 24-25.
Yes.
In the income tax return, it was 10,50,000.
Yes,
In 25-26, it is 6 lakhs.
Lordship,
So
yeah, in my
it's difficult.
no,
to
lordship,
believe.
kindly considers in my affidavit of assets, I have also lordship produced my resignation letter, lordship. That is at page 153.
Resignation letter from where?
From the erstwhile company. Now I am in a business.
What was your income at that point of time?
That 10 lakh, lordship. Lordship kindly.
10 lakhs.
Yes. Lordship kindly sees that page 153, lordship, volume 2. Page 153 is my formal resignation, and the acceptance, lordship, is at page 154. And my relieving letter, lordship, is at 155. Now, lordship, I am in a partnership business. I have also produced the accounts of that business also, lordship. Lordship will kindly come to page 282.
Ms. Chakraborty, learned advocate appearing for the petition.
And for the 125 proceeding.
That has not been adjusted.
No, that has not been adjusted. Even, lordship, the wife in her affidavit of asset has not even indicated about the pendency of those proceedings.
Mr. Yes. Yes.
Difficult case for me, my lord. Here the petitioner is the wife of the deceased husband tenant. Decree was passed ex parte. After passing of the ex parte decree, when the husband of the petitioner came to know, he filed a searching report, he filed an application on 9/30. Now, when he filed the miscase, during the miscase 40, he died. Now, when he died, then the wife stepped into and she filed miscase number 56 for substitution, her name to be replaced with the. Now,
Yes.
the trial court continued with the execution case and the proceed with the execution case. We pointed out to the trial court, look, there is my miscase 40 and 56 is pending. Kindly dispose of the first. Don't proceed with the trial case. The court did not hinder, say there is no stay. I'll proceed with the execution case. Against that, the petitioner preferred a revision application before the Honorable High Court. The Honorable High Court granted stay. Thereafter, the matter appeared twice and thrice, but the matter could not be concluded, is still pending. These are the orders.
So what happened? What is the impugned order?
Now, the trial court was waiting for the order of the High Court, rejected my miscase 56 also.
For
That was substitution of my 40 was my miscase
order 22, rule 9,
Yes.
miscellaneous case was dismissed.
dismissed.
So how revision is maintainable? You have to apply for restoration.
We have
How revision is maintainable? You have to apply for restoration there.
liberty.
After some argument.
To apply for restoration, there in that liberty is granted. In
Appropriate
accordance with law, the trial court will.
No. That will be done.
The trial court.
That will be done. Yes. Who is appearing? Yes.
My lord, I am for the petitioner, landlord, respondent, and
Kindly pardon me, Lordship. My that was rejected on contest in presence of the landed advocate. It's not a simple dismissal on the default.
Yes.
56 were rejected, saying that you have not.
No, it was dismissed for default.
No.
I think the आगे file टा दे. Last file टा. The instant case shall be and is dismissed for
But the
default.
language isn't correct. What they are asking for the court was asking for the petitioner to be present to give deposition. The petitioner could not turn up, and the landed advocate was present there.
Yes. He was not diligent. The conduct shows that he is not diligent to
So
proceed
we
with
were
the
trying
instant
to-
case.
We were
On
trying
the
to-
last occasion also, adjournment prayer it shall be dismissed despite there was an earlier order also.
So there
It
was-
shall be dismissed. For hearing of the miscellaneous case in default dismissed. That has been dismissed for default.
dismissed because
Cannot be on merits. It's for default.
that will help me. Yes.
My lord, in
Yes.
14, my lord, I am for the plaintiff, petitioner, respondent, and the landlord. My lord, suit for eviction and recovery of possession and mean profit. Suit was decreed, being aggrieved by the decree.
What do you want?
My lord, expeditious disposal of the appeal because my execution has been stayed.
You are the respondent in the appeal.
Respondent in the appeal.
This application under Article 220.
Lord, I am for the petition.
Yes.
Our Lord, by the impugned order,
Mr. Rocky, do I have any difficulty in taking up the matter? Do you know who are appearing for the parties before the
No.
trial court?
no, I do not know, my Lord. My
Please inquire.
counterpart,
Counterpart, please inquire. I'm making it not today. Because you know why.
yes,
Yes. Next, call the next matter. 16, yes.
I am for the petition, my Lord. My Lord, no.
Which court? This is. So this is also from the same court. Are you aware?
Senior division. Body put.
Tomorrow. Yes, next. Or if you can inquire, you can come back at 1 also.
I am trying.
Today also 1 at you can come.
I am trying.
Yes, 17. Who is appearing?
Yes, I for the petition. The petitioner is 83 years old, filed a title suit before the learned civil judge, senior division, Sadar Paschim Medinipur. And at present, the petitioner is suffering from various ailments. But the case is delayed by several adjournment.
This application under Article 227.
For the petition.
Yes.
The petitioner, being senior citizen, filed an application before Chairman Maintenance Tribunal Barasat Sadur, which was disposed of, and the chairman on 18 February 2026 declined to interfere with the case on the ground that it will lead to civil court. Now, thereafter, the petitioner filed an appeal under Section 16 of Maintenance and Welfare of Parents and Senior Citizens Act. But till date, no appellate forum has been constituted. This is my grievance.
You have said that you have. I cannot direct here for constitution of an appellate forum.
No, the constitution is a state government has constituted the appellate, but the section 15 says.
You have the copy of the act. Please give me the copy of the act.
District magistrate has to assign an officer not below rank of the district magistrate.
That
Clear out the
direction,
appeal.
that direction cannot be passed from here. For that, you have to avail of other resources. But if what is the challenge in the gift deed?
Challenge, it is fraud.
Then it cannot be decided by this tribunal. If it is fraud, you have to go before the civil.
23 is there. Section 23 is there.
23 is a different thing altogether. If the gift is a conditional one,
Yes, my lord,
and
kindly
with on that
kindly
condition,
appreciate.
but you are saying that the gift is has been challenged on the ground of fraud.
No,
that
that is another aspect. It has been challenged. It was rejected.
Please show me your
appeal
show me your application before the tribunal. Please show me what is the challenge. Let me see.
Annexure P1, page 11.
What is the ground? There is no ground in this application. You have not made out any case.
Actually, the
Please
petitioner.
see what is the ground. You have not stated any grounds why it should be cancelled. Unnecessarily, you will be wasting time there. Please see the application at page 14.
For filing civil suit at this stage.
May not be civil suit. You have to advise your client accordingly. But you have not
There
stated
is
any
no other
grounds.
alternative but to file civil suit. But that
That is for
needed
you to
court
decide.
fees.
But here also no ground for under section 23 for cancellation. That ground has not been made out here. On merits also, if that is entertained, subject to correction by.
Let the matter be disposed of by appellate tribunal. I have the right for appeal. Section 16. Let the matter be disposed of.
The immediate grievance of the petitioner.
I have taken this, I have taken this section. That one is Devashish Chandra.
Devashish Chandra or Chakravarti?
Chandra. Just now I have phoned telephonic message that my advocate on record says that One is Devashish Chandra, another is Pundendu Sarkar. And they are practicing in the Model Court.
Please inquire. It's not Devashish Chakraborty. Please
No,
inquire.
no, I have just now.
Sure.
Yes,
Yes. What is this matter? In which item?
item 15 and 16.
15 and 16. In both.
No, the Devashish Chandra is in item 15
Devashish Chandra is for whom?
for the plaintiff.
And the defendant?
Defendant might, the advocate on record.
Your advocate on record. Here is the advocate on record there.
No, Sajal Kumar Ghosh.
Sajal Kumar Ghosh. There. Item number
15 and 16.
15. 15. Yes, what is this matter?
This is I am for the defendant. I am not by the impugned order. The trial court rejected my application under Order 7, Rule 11. It is barred by limitation because 2 against the defendant number 2.
Order 7, Rule 11 rejected.
Rule 11 2 rejected. Because, my lord, it appears
What is the ground under Order 7, Rule 11?
that the suit was instituted against the defendant number 2 who has died prior to institution of the suit against a dead person.
Defendant number 1 is the legal heir of the defendant number 2.
How it could be? Because how it could be? Because
That's their claim.
look to the plain.
Yes.
They have implemented the defendant number 2.
Yes.
Defendant number 2.
Where is the plaint? Plaint you have not annexed.
Yes. I'm just defendant number 2. Died on 14th January 2022 and the suit was instituted 23rd May 2025.
Mr. Rokita, I'm making it not today. Please inquire for the not today. Item number 16. Please inquire again. Item 15, 16, I'm making it not today. Please inquire. 15, 16 not today. Yes, next.
19.
19, yes. Yes, Mr. Yes.
This is, my lord, a very serious matter and interesting that the additional district judge at the time of execution, my lord, had stayed on the prayer of a third party in the sense, my lord, my father, Bimal Kumar Mullik, alias Mundal, actually.
What is the order under challenge?
Order, my lord, your lordship already directed at page, my lord, 74. 71, your lordship, 71. Your lordship already directed, my lord, to the 70 relevant portion 72. If I am
yes,
my lord has got it.
Yes.
The CO 2739, paragraph 3, I
yes,
can disposed of by requesting the learned additional district judge.
Yes, issue with regard to the mentality of the application under section
My lord,
47.
And court, my lord, has called for a report from the, my lord, that is why I want to place before your facts. My father.
Mr. Mukherjee, sir, what do you want now?
I want, my lord, the entire matter has remained stayed.
All right. Petition is directed.
They are claiming.
Petition is directed.
The reference petition was already pending before the collector since last 20 years. And thereafter, in the year of 24, the reference petition has been forwarded to the
Reference application is pending.
pending before the LA collector last 20 years. After that, the petition was forwarded to the LA court in the year of 2024. And as a register, as a LA case
What
number
do you
7
want? You want the expeditious disposal. This application under Article 227 of
2018. Thereafter, what happened, my lord? The execution already filed before the LA court, being number execution 3 of 2019, and then after the state filed an appeal, being fat number 08 on.
here the execution case is pending, not the LA case, not the reference.
The appellant only filed the memo of appeal, my lord, but
This
no
application
stay
under
application is
Article
there.
220.
Yesterday, we endorse this, we not ask me to name of the landed advocate.
Yes, ma'am.
Calco, Badipur.
Yes.
Saharuddin Karim Akhtar Miller for the plaintiff and Vidyut Kumar Noskar for the defendant.
All right.
My
Yes, what is this matter?
early disposal of the
This application under Article 227 of the My lord, Passover matter, my lord. 23, yes. Please wait. Yes.
I am for the applicant, my lord.
Yes.
But this is an application, my lord, wherein my order 7, rule 7 was rejected, my lord.
Yes.
But the kindly see the plaint, my lord, page number 11. Well, the entire matter, my lord, whatever cause of action they have said, all are barred by limitation, and the court below has held that, my lord, some of the cause of action are still under limitation, but those are pertaining to Surface Act and barred under section 34 of the Surface Act, my lord. My lord, kindly come to the plaint, my lord. And I'll be very precise, my lord, and from paragraph 3, my lord, we started describing the cause of action, my lord. All are 2006, 2009, at best 2009, my lord. And whatever, my lord, it was paid, my lord, in within limitation is from starting from page number, paragraph number 17, my lord. And that is Surface action. He has filed one application under section 17 of the Surface Act, that is also pending, my lord. But still he wants to pursue this application.
Where is the plaint?
My lord, page number 11. The court has held everything what is written in the plate, but held that some of the cause of action is within limitation. That starts from paragraph 17, my lord. And that all pertains to Surface action, which is barred by section 34 of the Surface Act before the civil court. And that too, my lord, the petitioner has also preferred an application under section 70 of Surface Act before the DRT. That is also pending against the same cause of action. The plaintiff has not left any recourse, my lord. Before criminal court, before DRT, before consumer forum, everywhere he has approached.
how these reliefs are barred. Some of the reliefs can be entertained by the civil court. How can you say if some of the reliefs are maintainable before the civil court, plaint
my lord,
cannot be rejected?
Why I say, my lord, why I say, my lord, all the reliefs, my lord, which he has paid, my lord, the fraud and everything, those are pertaining to 2003.
The reliefs, this declaration, damages, how these are barred under
Why I
section?
say, my lord, he is claiming the damages out of the action taken under SARFAESI Act, my lord, and any action taken under.
Have you considered the judgment of Prabha Jain versus State Bank of India or Canara Bank, whatever it is? Have you considered that judgment?
My lord, that perhaps, my lord, if I'm
Yes, Central Bank versus Prabha Jain. That was considered here.
Yes, my lord, it was. I've seen, my lord.
Then,
but that was basically.
what do you say to that judgment? That judgment specifically decides there were three issues. Three reliefs were claimed. Two said it's barred. One maintainable before the civil court.
Yes, my lord.
Said,
my lord, I say, my lord,
and
that
that's
none
the
of the
issue
case.
of fraud. That has also been clarified in that judgment.
None of the
Have you brought that judgment?
Not right now, my lord. But my lord, but my lord, none of the cases in the plaintiff lordship sees are maintainable before a civil court, my lord. Because why I say, my lord, because
You have not challenged the measures under section 13(4). That can only be entertained under section 17.
my lord, he
Not
has,
other
challenged, he has challenged that measure, my lord. And whatever he says, my lord, the manager has went there and my lord, that has been challenged under criminal code. That and the manager was exonerated.
No, criminal code, that's neither here nor there. But
No, my lord, but
here the
my lord,
13(4).
why I say so, my lord? These things happened, my lord, in 2010, 9-10, my lord. And now he cannot challenge under 2022. This would.
That limitation is a mixed question of law and fact, cannot be decided at order 7 to 11 stage. That cannot be decided at this stage.
But my lord,
that has to be decided by trial.
I have taken, my lord, the point of limitation, my lord. The cause of action, I am not going beyond the plaint, whatever is written in the plaint.
Limitation.
My lord, the plaint says the dates, my lord. I'm not saying from outside in the WS, I have maintained that this is the date or whatever it is, my lord. I'm only considering the plaint, my lord. Plaint says all the dates when the cause of action happened, my lord. And the cause of action, which is the code below, is saying that it is mixed question and it can be some of the things are maintainable. That comes under para 17 of the plaint, my lord. Kindly come to before that 17. Everything is way ahead of 2010, my lord. And kindly come and all the action what he has written in the in paragraph 17, my lord, is pertains to SARFAESI action and nothing else, my lord. Anything other than that of SARFAESI action, my lord. So anything doesn't.
How the prayers come within the SARFAESI action? Please tell me.
My lord, the prayer
reliefs claim.
Reliefs claimed, my lord, but the body of the plaint nowhere says, my lord.
No, body of the plaint he has made out. He has stated all facts, but these are the reliefs claimed. Can the DRT grant these reliefs?
My lord, these reliefs which are claimed, my lord, are all barred by limitation because these reliefs comes out of a cause of action which is in 2002-3 like that, my lord.
Show me that it's ex parte barred. Please show me that. It's ex parte barred from the statements made.
My lord, from the plaint itself, my lord, lordship.
Show me which paragraph it's barred.
My lord, my lord, I'm showing the dates, my lord, only, my lord. My lord, from the beginning, whatever, my lord, kindly come to paragraph 3, my lord.
Yes.
He has taken a loan in 2006, my lord. After that, my lord, what happened? He has claimed some action that he was not available. He could not avail a contract of a tender, my lord, in the metro railway. That was in 2009. My lord, all the damages are based on that cause of action. My lord, 2009, my lord. And he is claiming a relief in 2022, my lord.
Limitation will be an issue in the suit that can be decided at the time of trial. Suit may be dismissed if it is barred by limitation. It can be dismissed.
But the limitation ground I can take in 711 also, my lord, because
711 it is ex parte barred by law. On that,
it is barred by limitation, my lord. If your lordship considers
barred by limitation, maybe of two types. One is a mixed question of law and fact. Other is ex parte barred.
I say because nothing has been pleaded that cause of action of 2009 is still continuing. So plaint is silent on that.
How that had been dealt with by the trial court on the ground of limitation, please show me. How your point of limitation has been dealt with by the learned trial judge. Please show me.
No, no, learned trial court has held that these are all questions of, some questions are that of, some prayers are within limitation. Impugned order says that. But that some questions, my lord,
Please show me that. If some reliefs are within the limitation, end of the matter, then it cannot be.
my lord, those reliefs which are within the limitation, that is barred under section 34 of the Certificacy Act.
Please show me that. Please show me the finding of the learned trial judge first.
Learned trial court has omitted that section 13(4).
Where? Please show me which paragraph, which portion. Please show me the finding. If you are not ready, you can come back on another day.
My lord, I can come tomorrow.
After
Item number 7, my lord, extension of interview, my lord, other side is here, my lord.
Please wait, please wait. Yes, call the next matter.
In item 24, my lord, Mr. Somraj Chaudhary appearing for the petitioner, praying for short password. He is in code number 551. His clerk has instructed, my lord.
All right. Passed over for 5 minutes. I'm coming after 5 minutes.
Lord, I am for the petitioner, my lord.
Yes.
This is my application where, my lord, my application for injunction in an title appeal was refused.
Application for
Injunction, my lord. I have come up against that order, my lord. The petitioner before your lordship is one of the appellant and the plaintiff as well. The predecessor in interest of the petitioner have filed a, my lord, suit praying for declaration and injunction, but that was turned down, against which we have preferred an appeal. In that appeal, we have preferred an application, my lord, for injunction stating that the, my lord, the defendant.
Please give me a minute, please.
My lord.
Judgment and decree passed by the learned trial judge.
Annexure P1, my lord. At page 12, my lord.
Were you enjoying an injunction order during the pendency of the suit?
My lord, at that point of time, I was.
Where is that? Where is that order of injunction?
Lord, that order I haven't annexed, but my lord, it is reflecting from the decree itself.
Where is your application for injunction?
My lord, in an appeal, in the appeal.
In the appeal?
Page 37, my lord, annexure P3.
When did you file this application for injunction?
Lord, this was filed on 2nd of April 2022.
It has been rejected in 2026. So you are without any order of injunction from 2022. So the appeal is otherwise ready for hearing. I am directing the appeal to be disposed of. Ashun.
Tomorrow for hearing of
I am directing
The opposite party plaintiff.
Yes.
Preliminary issue on maintainability. Either I can address it now or after Mr. Banerjee concludes.
Maintainability.
I'll just take.
39-2A.
What is the impugned order?
Order under 39-2A. Order under 39-2A, page 49.
No, my lord, it's under section 94 C and E read with section 151. That's what the order is. My lord, I'll just take 2 minutes, my lord, to explain the background of this, my lord. My lord, there's a suit which is filed, my lord, by the opposite party number 1, who is a shareholder, my lord, in respect of, my lord, a company, my lord, which is me. The defendant number 2
is basically under order 39.
No, my lord, there are 2 applications which were made. 2 applications which were made.
What were the 2 applications?
My lord, one under order 39 rule 2A and another one under section 94 CE read with section 151. And what have they got? Ex parte order, my lord, directing, my lord, all the directors to be present, personally present. This is the order, my lord, which to obtain, my lord, from this court.
Where is the order? Directing the directors to be present?
My lord, kindly look at, my lord, page 49.
49 is the impugned.
49.
I've never heard of, my lord, such a drastic order not served. 2nd August, my lord, they give a contempt notice. 3rd, my lord, the company enters appearance. 4th, my lord, an ex parte order is passed without serving. My lord, kindly see page 51. 49, my lord, it talks about, my lord, order 39 rule 2A. That's
Yes.
one application, page 49.
Yes.
And then, my lord, kindly come to page 51. At the top, 3rd line, the petitioner plaintiff has filed the present application under section 94C and E read with section 151 of CBC, seeks a mandatory direction to correct the sentences limited. And I'll tell, my lord, what that has also, my lord, been complied with. That's a different issue. But, my lord, this kind of drastic order. And then, my lord, page 55 is the ordering portion. Petitioner, my lord, has done, my lord, page 55. The petitioner,
55, where is the direction that the directors are to appear personally? Where is that?
my lord, 2nd paragraph. Dependent
Personal appearance.
want to set further date to take personal to the court on 3rd September.
Yes, Mr. Thakkar, why personal appearance?
They can appear through VC.
No, why? What's the purpose of personal appearance?
And there is an order which is made in violation of that order.
There's a procedure. Please show me that for that the personal appearance can be directed. Under what provision?
May I take 5 minutes, my lord, for this background of this matter? Just 5 minutes.
Well, yes.
It's more drastic than that.
Procedure which has been followed is perhaps borrowing a leaf which your lordships follow. A rule is issued, persons have to be present, personally present.
Rule
Where is the rule?
In this case, there's no provision for a rule yet.
Rule means there is a prima facie satisfaction, thereafter rule. Here only there was a direction for administrative order. You file an application and personal
An
appearance.
ex parte order. This is ex parte.
Civil rules and orders I checked, Malo, they don't have any options dealing with subject to correction dealing with time. There doesn't seem to be any rules which have been prescribed dealing with time.
But why this personal appearance? This is not done. This should not be. With personal appearance on the very first day.
And not served. Not served on us.
Interim order of injunction, implementation, violation.
Well, on 19th May, the order was passed.
Ad interim order of injunction, they are aware of it. After
Not
the
served on the
injunction-
directors.
No, it's served on the company, it's served on everybody. The directors act upon it. Once this order is made, they try to rectify the order which is
No,
or
before that.
overcome, or
No.
purge the content. rather.
No, whatever it might be, it's a different. I'm concerned with this personal appearance. Why this personal appearance?
I'll take instruction. Well, I was on whether
Tomorrow I'm keeping this. Please take instructions.
My lord, kindly stay this portion, my lord. Kindly stay this portion.
What is the next date fixed? 3rd of September. 3rd of September, I'm taking it tomorrow. Let him take instructions.
Instead of tomorrow, my lord, can we Friday, my lord?
All right.
24th.
Hard, heavily contested matter I've fixed.
No, this shouldn't, my lord, take my lord, much time, my lord.
No.
I think, my lord, Mr. Thakkar, my lord, will see some, because I'll show, my lord, the drastic nature of, my lord, what has
I'm
happened.
keeping it on 25th. So your date is on 3rd of September. Yes.
My lord, then 26th, I'm sorry.
26. All right, 26.
Huh?
Then I'm
Then
making it 25th, he will not be here.
25th, my lord, I have some difficulty. And 27th, Monday, হচ্ছে না, যাচ্ছে হবে Monday.
All right, 27th. Yes, call the next matter.
Lord PMT under section. Lord
Caveat.
Lord,
you have been served.
Lord PMT under section.
Both courts. Both courts.
Lord, both court. Ground is short deposit. Trial court directed for deposit. Trial court directed to pay balance. No. Trial court directed to pay balance.
After the period of limitation.
After the period of limitation.
Could not have been done.
And then, Lord, the appellate court also passed same order. Lord, absolutely, my Lord, contrary to the judgment of Abdul Mutin. I have brought the judgment of the Abdul Mutin.
Yes.
Lordship kindly sees the deed. In the deed, Lordship, the consideration had two parts. One part for the vendor for the land. The other part to a confirming party who has spent some money for developing of the property and for litigation purposes. I say, Lordship, that amount comes under the heading of other sum as stated in section 9. Lordship kindly sees the deed first.
No. Your Lordship then kindly come to the finding. Let us come to the finding. Kindly come to the lower court finding, then I shall come to the deed.
Please give me a minute.
Lord, page 47.
Please give me a minute.
Sir, আপনি ট্রায়াল কোর্টের অরিজিনাল অর্ডারটা দিয়েছেন সার্টিফাইড কপি আমার এটা তো দেননি
আছে পেজ 47
না ওটা তো সার্টিফাইড কপি না তো তাহলে এমনি কি করে করছেন
এটা আন্ডারটেকিং দেওয়া যাবে এই তো আপনি ঠিকই বলেছেন
তাহলে স্যার আপনার
আরে ওটা তো টেকনিক্যাল ইনফরমেশন
মানে এটাও টেকনিক্যাল পয়েন্ট
The trial court judgment towards the bottom 47, 48, 49.
Yes. Mr.
Lordship, kindly come to page 47. Trial court judgment.
You have not annexed the certified copy of the trial court. 47.
47. towards the bottom, my lord. Thus keeping in mind and they were directed, Lord, to deposit. Preemptor was directed to deposit balance 5,50,000 within 20 days. Accordingly, execution was filed, deposit was made. Page 49. $9,62,000.
Barasat Eye Hospital was decided when?
After this.
No.
Yes, Lordship, I have. It was decided on October 17,
So I have a faint recollection that is after this.
2019.
Because I appeared in this matter. I know when it was passed.
Yes.
Barasat Eye Hospital, I appeared.
Barasat Eye Hospital.
Yes.
Thereafter, Lord
So, Abdul Motin is after that.
After that.
So this
Lord,
is the first
Supreme Court
judgment.
judgment is always retrospective unless it is said to be prospective. Lordship knows that.
Yes. So
Supreme Court judgment is always, because interpretation of the law is always prospective, not prospective, retrospective operation, unless it is made prospective by the judgment of the Supreme Court.
Mr. Banerjee, only one thing. In Commercial Courts Act, the same problem arose. It said, no, this has to be prospective, and insofar as the previous matters are concerned, cannot be done.
But
That's the
that
judgment.
question, my Lord, if your
Here,
Lordship kindly
Mr. Banerjee, only one thing. The view was, at that relevant point of time, the view was that after inquiry, if it is made, then. But the question, Mr. Chakraborty, is another. In this matter also, it was in the first time before because Kaustubh Mondal, who was the respondent before the Honorable Supreme Court, he won in this court also. He was the preemptor. So
Lord,
they are
one
also, our court held, no, it's not required after 9(6). After that, in section 9, after it is decided, then. In this matter also, the Honorable Supreme Court, after holding, did not give liberty to deposit that.
No,
amount.
but in this
So
case,
if that is so, then in that matter also it has not been given. So it's a declaration of law. It will appear in pending matters also.
And Lord, doctrine of merger, trial court judgment 18, the appeal court judgment 26. Lord, doctrine of merger will apply.
Here also, I think there was a prayer to make, if I faintly recollect, that there was a prayer that to allow, yes, paragraph 34.
Yes.
The last question that which arises is whether the respondent can now, that is Kaustubh Mondal, who succeeded before the High Court, granted time to deposit the balance amount. When the direction was so passed in pursuance of the order of the appellate court, the respondent still assailed the same. The requirement of exercising the right within the stipulated time in respect of the very provision has been held to be sacrosanct. That is, there can be no extension of time granted even by recourse to section 5 of the Limitation Act. And once the time period to exercise the right is sacrosanct, then the deposit of the full amount within the time is also sacrosanct. The two go hand in hand. It is not a case where an application has been filed within the time and the amount is deficient, but the balance amount has been deposited within the time meant for exercising of that right. We are saying so as such an eventuality may arise. That is a view that you may have filed with a deficit consideration amount, but within the period of limitation, you remit the balance amount. Yes, that's permissible because if it is within the period of limitation. So after this, you have deposited the balance amount.
After 13 years.
Order of the learned
After
panel
13
judge.
years.
Yes.
After 13
How
years.
the appellate court has decided, dealt
Appellate
with
court
this
kindly
issue.
come to the appellate court judgment. Appellate court judgment, Lord, last page of the judgment. Last but one page has already been deposed by OPW1 in its cross-examination.
Page?
Lord, there is
11.
page
10 of 11.
Page 10 of 11. It has already been deposed in the cross-examination that he cannot file any document showing payment of rupees so and so, payment and in so and so. However, the trial court in the impugned judgment has already directed to the petitioner to make deposit of the sum of rupees 8,875,000 and the additional compensation money at 10% so and so amount, rupees so and so, when the court, since the petitioner have already deposited 4,12,000 so and so, although calculated, they are now required to deposit the balance amount of rupees so and so through appropriate challan. Admittedly, as per direction of the trial court, in the final order of the judgment, petitioner has already deposited the balance amount of rupees 5,50,000 after 13 years. Lord, palpably illegal, my lord. And this is after Nitin Mollik. After Nitin Mollik, my lord. By doctrine of merger applied 26, judgment delivered in 26 by the appeal court. And the recital, blood 8,75,000 in the deed.
Recital?
Recital in the deed.
Where is that?
Kindly come to the recital of the deed.
Page 63, Lordship, it starts. Lordship will kindly come to page 73.
75, kindly come to.
Before that, 73, my lord.
I am now speaking.
Page 73, where?
75.
Lordship, second last paragraph onwards. Whereas while seized and possessed the aforesaid purchased landed property as absolute owner thereof, Surendranath Burman died intestate on such and such, leaving behind the surviving present owners herein as his only legal heirs and successors. And according to the Dayabhaga School of Hindu Succession Act, the vendors have become the joint owners in respect of the aforesaid property. And whereas the party thereto of the first part, with intention to develop the aforesaid property, entered into an agreement with one Noni Gopal De on such and such for development of the said property. And whereas subsequent to the aforesaid agreement was not honored, and accordingly the said Noni Gopal Dev filed a title suit before the learned such and such against the vendors herein. And whereas the aforesaid suit was withdrawn by the said Noni Gopal with the intervention of the well-wishers without taking any leave, and accordingly the vendors herein entered into a fresh agreement on such and such with the said Noni Gopal for selling out the aforesaid property in favor of Noni Gopal Dev and in favor of his nominee. And whereas before selling out the said property, to this present took the measurement of the said property to a surveyor, and on survey the actual measurement of the property under sale comes to such and such. Whereas the vendors have agreed for absolute sale of the aforesaid property to the purchaser, hearing being the nominee of the said Noni Gopal Dev. Now, during the subsistence of the aforesaid deed of agreement, the confirming party herein invested a huge amount of money towards the development of the said property and also for the litigation expenses.
Oh, they are confirming party.
I
Both
get
have
according to you,
vendor.
previous agreement was 3,75,000.
Yes. No, me 3,75,000.
There was an agreement with the developer. He invested 5 lakhs and odd. So, but now when this transfer is being made,
yes.
So otherwise if the confirming party, he would not confirm with that.
Yes.
So to perfect the title, this value was fixed. That's the consideration money.
But Lordship, kindly see whether this comes under other sums, because Lordship will kindly see Barasat Eye Hospital. Lordship will kindly come to paragraph 26 and 27.
Other sum is not with regard to this. Other sum is with regard to after purchase this deed, if any other further sum.
Lordship kindly sees the language of 26 and 27 once.
Yeah, 26 and 27 of
Barasat Eye Hospital.
paragraph.
Yes, yes, ma'am.
Yes.
I'm reading paragraph 27. Now the question now is as to what would be the nature of inquiry which has been envisaged to be carried out by the Munsif. If section 9 as it reads is perused, then first the amount mentioned in the sale transaction.
1 minute, please, my lord. That is immaterial because both are the
Mr. Banerjee,
purchasers,
let
both
us
are the
submit.
vendors.
You will be getting your chance.
Is to be deposited as per section 1 of 8 of the said act. Once the amount is deposited, the next stage is for the Munsif to give notice of the application to the transferee. The transferee thereafter, when enters appearance within the time specified, can prove the consideration money paid for the transfer and other sums. Such other sums, if any, are as properly paid by him in respect of the land, including any sum paid for annulling encumbrances created prior to the day of transfer, and rent or revenue, cesses or taxes for any period. Now, Lordship will come back to the deed. Now, your Lordship will kindly come back to the deed at page 74, Lordship. After Lordship, the suit was withdrawn, Lordship, in the third paragraph, the second whereas. Lordship kindly sees the vendors herein entered into a fresh agreement on 24/4/2003 with the said Noni Gopal for selling out the aforesaid property in favor of Noni Gopal Dev and or in favor of his nominee. So another fresh agreement was entered where Lordship, this present vendor, the purchaser, was not a party. And then Lordship, the paragraph thereafter, and whereas the vendors are agreed for absolute sale of the said property to the purchaser, herein being the nominee of the said Noni Gopal Dev.
Purchaser was Bablu Mistry.
Yes, he is the preemptee.
Purchaser is Bablu Mistry and seller is Roma Bormon and others.
Yes.
And where is the confirming party?
Party, my lord.
Noni Gopal Dev.
Yes.
And Noni Gopal Dev.
That is at page 71.
And your lordship
Yes.
will get it. Not get it from the two cause title, recital, page 75 recital. Lordship, kindly, it will be clear.
Yes, Lordship,
Page-
let me read.
1 minute.
It will be clear.
Yes,
Let
kindly,
me read, Lordship.
kindly allow me to speak. Page 75, my lord.
The last
second, third
is
paragraph.
also important, Lordship.
Yes, both are. Both I will place before this honorable court. Page 75. And whereas the purchasers.
No. Only one thing, Mr. Banerjee. Please kindly come to page 80.
Page
Page 80 of the civil division application.
80.
Yes, memo of consideration.
Memo of consideration.
Yes, 3,75,000.
No,
This is
this
the.
will, no,
Please
this
see,
will be
that's the
clarified.
memo of consideration.
No. Your lordship kindly come to page 75 first.
75, yes.
As a whole may be read.
Yes.
The deed must be read as to be read as a whole.
Yes.
Lord first, Lord, then Hebendam Club. Lord second
Mr.
paragraph.
Banerjee, this is to be hard.
And whereas
Mr. Banerjee,
no,
this is to be hard.
No, need not be hard. Lordship, kindly read
Be
this.
hard.
Kindly read this, my lord. The purchaser being interested persons for purchasing the said property, more fully described in schedule here under. Approach to the vendors, confirming party herein, and has offered rupees 8,75,000, less 75,000 only by purchasing the said property
No.
with the
Sorry.
vendors and
Oh, in
confirming party
84.
hereafter.
No. In 84, no. That 5 lakh is considered.
No. 5 lakh. Then 84.
Sorry, I was
5
under the
lakh.
impression
Therefore,
because
both-
after that, that
both
sketch
have
map was.
transferred the property. Nothing, Lord.
First lordship, the confirming party
No,
did
no,
not
no.
have any title,
That
which is
property
clear
was
from
sold
this
in
lordship agreement.
8,75,000.
Mr. Chakraborty, only one thing, the confirming party had some right, some encumbrances to make it encumbrance free. This amount was paid.
But why this amount was paid, that has also been explained at
maybe-
page 75, my lord.
Yeah.
Kindly comes.
He prayed for PM son in respect of this deed.
75, yes.
The first line, the party therein took 5 lakh from the purchaser herein and confirmed the sale, as he has no claim or demand over the property hereby conveyed and on vendors and in favor of the purchaser in respect of the said property, and also to avoid all future complication, intends to cancel the deed of agreement dated such and such, relinquishing his claim to the
Obviously.
property, thereby conveyed to the vendors.
Lord, obviously.
This 3,75,000 is the actual price of the property which lordship the vendors took. And this 5 lakh lordship, he has categorically stated, lordship kindly sees at page 74, the last paragraph, that during the subsistence of the deed of agreement, the confirming party herein invested a huge amount of money towards development of the said property and also for litigation expenses. So these were other expenses which the confirming party bore. He did not have any title in the property. And lordship, subsequently another lordship agreement both these parties entered into. That is also on lordship 24th of April 2003. So lordship, these 5 lakh was a price for relinquishing that right. And for selling, since it was being sold to his nominee. It clearly comes under lordship the other sums as lordship contemplated under section 9.
Yes.
So lordship, this amount was only paid so that he does not have any claim. It was a hush money. He doesn't create any problem in the future. And lordship, under section this paragraph 27 of the Barasat Eye Hospital, it clearly comes within the ambit of other sums, lordship, which the learned Munsif, at the time of deciding this application, has found that I have to pay that also, and within the time frame fixed by the Munsif, I paid it. On that day, Lordship, Barasat Eye Hospital was not there. Even when the day when I paid it, Barasat Eye Hospital.
Eye Hospital also, that was not allowed. So please
But this
appreciate this, because that point was also raised. Please allow me. That was not granted.
But here, Lordship,
because the subsequent judgment you will be also finding delivered by, I think, Justice Shah or by Justice
Abdul Matin.
On this.
Yes, Abdul Matin also I have got.
Abdul Matin, I have got.
Abdul Matin Mullik.
Yes.
Abdul
By
Matin,
Justice Shah.
Abdul Matin.
There, I think, paragraph 8 or 9.
8, 9.
Paragraph 8 or 9
absolutely.
says that it's a weak right and this time limit is.
Lord, other sum means 10%. In the
No,
Eye Hospital
no,
case,
Mr. Banerjee. Other sum is not 10%.
Lord, in Bharat
Other sum is not 10%.
In
Other sum is not
amount, right,
10%.
but Lord, in Bharat Eye Hospital cases, other sum 10%.
The right of preemption is a very weak right. That being the character of the right, any provision to enforce such a right must thus be strictly construed.
Yes,
so here is the question: how that section 8 and 9 is to be construed?
Lordship.
So that is to be strictly construed.
Yes.
Meaning thereby that if something is required to be done within a specific time frame, you have to do that.
Otherwise,
now the only question is whether, according to you, this 5 lakhs is another sum that requires an adjudication. So that can be directed to be deposited after adjudication. That's your submission, and Mr. Banerjee's submission is that no, it's a composite amount mentioned in the deed of conveyance. So the entire with 10% thereof ought to have been deposited at the time of filing the application. A portion thereof cannot be deposited or could not have been directed to be deposited beyond the period of limitation. I think that's the issue.
Yes.
And Lord, he accepted that.
I'm reserving
He
the judgment.
accepted by depositing. He accepted by depositing.
Yes, anything, Mr. Chakraborty, do you want to cite any judgments?
No, Lordship, apart from these two judgments, Lordship, there are no judgments.
No,
Basically.
if you want, because this is an issue, I think there's no judgment directly on this.
Lord, page 75 and
These judgment can be
only one.
retrospective or prospective. Then on that point, I can cite other judgments.
I'm not on that, my lord, because prospective also cannot be, because pending application. Lord,
No, because I have to
doctrine of
deposit
the
it within that time.
pending application by
Mr.
Dr.
Banerjee, if she wants to submit, please let her give, because this is an issue. I don't think there is any direct decision on this point. This is a peculiar thing. One is, Mr. Banerjee, there are two things. Here, it's what vests. It's the right of the transferee that will vest. Now, merely on the basis of an agreement, if something is done, whether that created any right or that, and which should be a sum to be treated as a consideration, that is to be also considered. If you both of you want to make submissions on that, I can give you time. That is what I'm telling you, because these are the issues which has to be taken into consideration. What vests? It's only the right of the transferee which vests. So there is no question of vesting of the conforming party's right, because he has not acquired any right. Might be some encumbrance. Might be some encumbrance. That is a different thing altogether. So whether that would be included within the amount of consideration or it has to be segregated.
That answer is to be given from page 75 and 76.
So,
Addendum clause, total consideration money for the city is
Mr. Banerjee, if you want to make
8,75,000.
submissions, I can give both.
Both have taken money by transferring their property.
Both of Mr.
And this
Banerjee,
is
both
the-
have taken money.
For
But
separate
what will vest?
purposes.
Please take
So Lordship
consider
wanted
section
to- Lordship
section 9.
Here on this
10.
point.
Please
Lordship
kindly see
wanted to
section
hear
9
on
and
this
10.
point, hear it. But in the Lordship wanted to hear on this point, hear it.
Yes.
But difficulty is this, that the execution cannot be levied. For
Mr.
taking
Banerjee,
possession meanwhile.
Mr. Banerjee,
No, your Lordship will hear it.
succeeded in both courts.
Right.
Yes, succeeded in
Right.
both courts.
Right.
So the now the execution has to be stayed.
Right.
Execution, Mr. Chakraborty, has
And
to be
not to
stayed.
transfer income but the
Yes,
property
yes,
in the
that you
meantime.
cannot do. But only thing that is what, please take section 10.
Right, my lord.
The right, title, and interest
Yes.
of whom?
Yes.
Of the riot.
Right.
Whose riot? Two things. Of the riot and of the transferee. Meaning thereby, it's the original person who transferred. So here it's that Bormons and other things. They were the riots. So they transferred in favor of Bablu Mistry and others. So those Bormons' right, as well as Bablu Mistry's right, that would only vest. Nothing more than
One
that.
is tangible right, another is intangible
Yes, so
right.
as per the
Now,
statute,
intangible
these are the
right
two
is also a
vesting.
right. Yes, that is I will argue before your lordship.
That is what I'm telling
Tangible
you,
and
because
intangible.
there are
Yes.
some, so these two things will only vest.
Yes, lordship.
Nothing.
Lordship.
That will be clarified if you kindly come to the proviso of section 10A. Provided that the transferee of the person mentioned in subsection 2 of section 9 shall have the right to take away the crops. So that if certain things transferee, he uses
very
that for
interesting
cultivation.
question, my lord,
crops.
your lordship
So
hearing.
with the vesting of the land, he can take away that will not vest. Right in those standing crops will also not vest. So if that is so, whether this also will whether that can be said to be a consideration. Because if there's a
lordship will hear it.
I am not aware of any decision on this. If both of
Lord,
you are
I
aware,
will bring
because I have
the
not come across.
Lord, all the judgment let him, Lord, later argue on that to that extent. Lord, I will, Lord, certainly. Lord, may I take your lordship kindly?
Another matter has been called on.
Yes, already taken up.
Can you wait, because I will be framing the question now. That is why.
Yes.
163. What is that matter?
My lord, that dilution of 6 months fair trial period. My lord, my lord, yesterday, my lord, there are two judgments, my lord.
All right, please wait. After this, I am taking. up. Yes, this is 27.
27 Lordship, I am for the Lordship preemptive petitioner praying for expeditious disposal Lordship. The preemptor filed an application for preemption along with a prayer for permanent injunction. On Lordship 15th February 2023, injunction application was granted. It is continued till Lordship 2026.
Application under Article 227 of the Constitution. All the next matter.
Dependent is the petitioner Lordship, suit for Lordship, permanent injunction, injunction granted Lordship on.
What do you want?
Expeditious of the Lordship pending application along with the Lordship suit.
Injunction application?
Yes, Lordship, I am
What is the suit for?
Suit for Lordship permanent injunction.
This application under Article
Admitting that the
this application
dependent.
Expeditious hearing.
Expeditious of the partition 2016 Lordship, the application for injunction is pending.
This application under Article 227 of the Yes. Call the next matter. 30 yes.
This is also for expeditious disposal.
Of?
With respect to OA application pending before LRTT Lordship.
No,
Last
sir.
date was 15/5.
No, sir.
Lordship, the next
Please
date
go
is
before the division bench. Cannot be before the single bench. In view.
One 163,
163 টা রাখুন। Yes.
My lord, this is a division bench judgment, my lord. Mr. Tanmoy Mukherjee, my lord, appreciated me, my lord, in the course of the hearing, my lord, yesterday. But my lord, one 163. But my lord, in my humble submission, my lord, this order, my lord, is
There is a contra division bench judgment of our court. Then,
my lord, then my lord, the Supreme.
You want to rely upon this?
No, no, no. I don't want to rely upon this, my lord. As such, I have told my lord, yeah, my lord, taken time, my lord. Yes,
this cannot be decided more so in a civil division application.
Yes. Yes.
Because
Yes,
of
my
the
lord.
divorce.
That's why, my lord,
I cannot direct this waive of the cooling off period.
Yes, well, and this is, my lord, in one
In a
paragraph.
first appeal might be against the degree for divorce or such and such.
Yes.
The parties said yes,
Yes.
we will be filing.
Yes, this is not the as I told.
And there was a direction that you have to approach that.
Yes.
If you have to approach that as per the Supreme Court's judgment, that court is the only court who can decide to waive. No other court.
Yes, my lord, but that's why, my lord, I don't want to praise this, but as my lord, said yesterday, my lord, that I'll produce the judgment, my lord, I produced the judgment because it was randomly told by me in the course of the hearing, my lord, that this exists, my lord, but my lord, this judgment is, my lord, something else, my lord.
When the application was filed?
My lord, the application was filed on, my lord, কত তারিখ ফাইল করলি? এখানে দেখ এটা নে কত তারিখ ফাইল করলি অ্যাপ্লিকেশনটা কই তোর এটা কেন হলো লাস্টে তো কিচ্ছু তুই এজিনেট করে রাখবি না তুই এখানে এসে হাত রাখ এই তো এটা তো কত তারিখ করলি মালার 5th of August. Malad, kindly seize the judgment at certified copy, Malad, 5th of August.
Do you have the copy of that Amardeep Singh?
Amardeep Singh, yes, my lord. My lord, but this is a academic copy, my lord, kindly. Mordeep Singh আর আছে?
Amardeep Singh, you did not place that.
No, Amardeep Singh, no. Amardeep Singh, yes, my lord, it was placed, but it was not reflected in the order, my lord. All the judgments were placed.
Amardeep Singh only declared the law with regard to whether it's directory or mandatory. Amardeep Singh did not pass a decree on mutual consent.
Amardeep Singh also gave the parameters on which this will be decided as it is mandatory or directory.
Ashun, this application
has already mentioned the matter in the morning. That it's that RERA matter, your lordship. We have invoked the 227 jurisdiction, my lord. We have deposited the sum, my lord, as directed by my lord. My lord, kindly, my lord, I'll come at 4:30, your lordship, for 5 minutes, your lordship. 5 minutes, 4:30, my lord. My item number is 90, your lordship. My lord will take up 90 and 90.
90.
Huh.
Millet, I take your lordship's indulgence, Millet. In the morning, I mentioned your lordship has granted me leave, Millet.
Yes.
But no date has been given, Millet. Millet, unless the matter is taken up tomorrow, they will be evicted. That's the urgency, Millet.
Say tomorrow it will be.
Oh, the
yes.
officer has not given any date.
Calculate. Yes. Yes. All the extension যেটা ছিল। Yes.
Yes, my lord. But there is a talk of compromise going on between the parties, my lord.
Yes.
We are exploring new possibilities of the settlement, my lord. Kindly, my lord,
Yes, my
discuss the
lord,
entry order within which, my lord.
There is, most of the shares has been sold to the petitioners. My lord, the only share of the petitioner number one, the only, sorry, opposite party, one of the opposite party is remaining. My lord, the
Talk of settlement is going on.
my lord, going on, kindly keep it any day. Further, my lord, I think by that time it will be settled.
Let the interim order be extended, my lord.
The land
My lord. My lord,
Yes.
the petitioner before your lordship is the defendant in a suit for eviction on the ground of reasonable requirement. My lord, in this,
You are the defendant.
a defendant,
Yes.
my lord, I have taken out an application for amendment of written statement at the stage, my lord, when the trial has commenced. PW1 is complete. My lord, I have prayed for amendment. Kindly have a look to my amendment application. My lord, my submission is, my lord, the page 15, my lord.
Give me a minute. Please give me a minute.
Yes, my lord, schedule. Schedule is, my lord, 18, page 18, my lord, schedule.
Please give me a minute.
Yeah, the defendant is also a tenant in respect of one room.
Give me a minute, please.
My original written statement is, my lord, this is my original written statement.
Please give me the plaint also.
Plaint is not with me, my lord. Plaint.
You don't have the plaint. Give me the written statement.
My lord, this is plaint.
Not legible.
Yes, what is the case which you wanted to make by way of amendment?
My lord, there is, my lord, two rooms, one suite room and another, my lord, non-suited room. My lord, there is a partition. Both the rooms are used by the defendant for his business purpose. My lord, my apprehension is this. My lord, if the
So
suit
the
is
suit was filed only in respect of one room.
one room,
So according
there
to
is
you,
no
you are the tenant in respect of two rooms.
two rooms.
Yes, so you
Both-
wanted to bring the fact of the other tenancy by way of amendment.
Yes, my lord, because my lord,
That you wanted to make.
yes, my lord, this particular amendment, if it is allowed, the plaintiff will not be prejudiced in any way, my lord. And
What was your case in the written statement? You are a tenant under one tenancy or two tenancies?
two tenancies.
So
My lord, there is one suite room, that is one tenancy, and then beside this, my lord,
yes.
another tenancy. There is no whisper in the plaint, my lord, itself.
So that case you have made out in the original written statement.
No, my lord, that was not made out, my lord. That
You have
is
not made.
no, my lord. That's why I, my lord, wanted to file this amendment application for way of amendment.
Are you sure?
Yes, my lord. That is not, my lord. That was not make out.
Yes, your paragraph 11 of the written statement.
My lord,
Please check up.
my lord. That the said Surjonath Misro further inducted in all additional room of the ground floor of the said premises, as a result whereof the present defendant is holding two tenancies, one in monthly rental of rupees 165 and other at a monthly rental of rupees 95.
So 95 you wanted to bring by way of an amendment.
Yes,
That
my
is already there in the written statement. Please give it to me. Yes. Give the written statement. This application under Article 2. Yes.
I beg to appear on behalf of the petitioner. A respondent in a miscellaneous arbitration case is the petitioner before your lordship. An application for appointment of an arbitrator under the old Act of 1940 has been allowed by the learned court below.
Nineteen 40.
Yes.
Where is the application?
Application at page 4. Application starts, Lordship, at page 15, Lordship. Prayers are at page 26.
You have a copy of the 1940 Act.
Yes.
Yes, what is the difficulty?
Lordship kindly takes up section 85 of the 1996 Act. It is the repeals and savings section, Lordship. May I just place this for my lord? The Arbitration Protocol Convention Act 1937, the Arbitration Act 1940, and the Foreign Awards Recognition and Enforcement Act 1961 are hereby repealed.
No, earlier there was an arbitrator appointed under the
Yes.
1940 Act.
There was an arbitrator appointed.
Yes.
Lordship, then if my lord takes up page 40 of Lordship's brief.
Yes, notwithstanding such repeal, the provisions of the said enactment shall apply in relation to arbitral proceedings which commenced before this Act came into force. So this is a proceeding which commenced prior to.
Proceedings which commenced.
So 40 Act will apply.
Lordship, may I just point it out? In 2007, the erstwhile arbitrator Justice Lilamoy Ghosh was acting as the arbitrator. In 2007, he recused himself from the arbitral proceedings, saying that he had become functus officio. Lordship, there is a letter from his lordship.
Why functus officio?
Because Lordship, first there was one arbitrator, Mr. Mondol. He was there for 45 sittings. Thereafter, Justice Ghosh was there for another 39 sittings. Lordship, in the meantime, the petitioner had gone to BIFR. Thereafter, after coming out of BIFR, Lordship, the petitioner once again, the arbitral proceedings were sought to be commenced, but his Lordship said that he had become functus officio and he shall no longer be able to perform the duties of the arbitrator. So my contention specifically before the learned court was that since learned court below was that since the arbitrator himself had declared himself to be functus officio, Lordship, the proceedings had to start afresh. And Lordship, the appointment thereafter would have to be as per the provisions of the 1996
How that
Act.
submission of yours have been dealt with?
Lordship, that submission, Lordship kindly takes up internal page 4.
Yes.
Of the order impugned. The learned advocate for the Lordship, this is a decision which I relied upon. This is a decision which I relied upon, Lordship, 1999 9 SCC. Lordship, here the Supreme Court was pleased to observe that the learned counsel for the respondent number 2 and 3 submitted that once the appointed arbitrator had resigned, a new arbitrator would have to be appointed as per provisions of the 1996 Act. And the appeal in which the arbitrator was appointed would not survive any further. Learned counsel of the appellant, on the other hand, joined issues and submitted. Under circumstances, appeal can be heard on merit. So I relied on this judgment, Lord. If I may just hand over a copy of that judgment to my lord.
1999-9.
Yes. It is a very short judgment, Lordship. In this case, Lordship, an aspersion was cast upon the erstwhile arbitrator. Matter had gone up to the Supreme Court.
It was not decided. That issue was not decided here. Then
Lordship,
submissions of both were recorded.
submissions of both.
How can it be a ratio?
Because Lordship now kindly takes up for once page 40 of my Lord's brief. That is the letter.
Yes.
By which Justice Leelamoy Ghosh
No,
was
he has resigned.
he
But
resigned, as also declared himself to be functus officio. So once the arbitrator declares himself to be functus officio, Lordship.
functus officio for what? Why?
Because Lordship was this matter prior to his Lordship's recusal was at the stage of publishing of the award.
Yes.
So now if this matter has to be heard, it has to be heard afresh from the beginning.
Yes.
So
The
Lordship,
question is whether 40 Act or 96 Act. So if the proceedings was admittedly initiated
yes,
under
that is
40
an
Act.
admitted position, but
So in the meantime, there has been resignation. 85 squarely protects that.
85 protects, but Lordship,
Then
my contention,
this judgment you have cited, this does not decide that issue.
Lordship,
Then
this was only for the purpose of showing that, Lordship, that there is a decision of the Supreme Court which says that if the erstwhile arbitrator retires, Lordship, here was a case where the arbitrator.
here it has not been decided that only the submission, that it has to be under 96 Act. Appeal cannot proceed. The other side joint issue said no appeal can proceed. The Honorable Supreme Court has clarified that we are not expressing any opinion
Lordship,
on that
there are
issue.
judgments to that effect that if the the provisions of 1940 Act will continue to apply in proceedings which are continuing, but here is a proceedings which has stopped, and this application, Lordship will kindly see that the judge had recused himself, the arbitrator had recused himself in 2000.
Yes, arbitrator recused, arbitrator has resigned, everything fine. So there has to be a new appointment. There is no dispute on that. 1940 Act will prevail as per the section 85(2). Why 1996 Act?
Lordship, my contention would have been, since there was a halt in the proceedings and the proceedings would have to start afresh, Lordship, after coming into force of the 96 Act. Lordship, that is why there was an objection raised with.
No, these decisions you have not brought. 1999 Supreme Court 1535.
Those were cited by the petitioner. Those are with regard to the continuance of the arbitral proceeding,
Yes.
not with regard to the fresh appointment. What happens in case if an arbitration recuses and then a fresh appointment has to be made? Lordship, I admit before my lord, I bow down that if a proceedings is continuing under the 1940 Act, even after coming into effect of the 1996 Act, the proceedings would have continued under the 1940 Act. But here is a case where the proceedings came to a standstill for almost 13 years, nothing happened thereafter, Lordship. Then they come up with an application under the 1940 Act. With regard to continuance of the proceedings, Lordship, I bow down. Proceedings could not have, that is the protection extended under 85(2) of the Arbitration Act. But with regard to appointment, Lordship, that point has not been decided anywhere.
Do you have any authority in your support which says that?
And I
This
have
judgment-
extensively searched, and this is the only judgment which comes closest to what I want to submit.
Ashuna, this application under Article 227 of
looking for judgments. On this point, Lordship, I found several judgments which record that under the 1940 Act, a continuing proceeding shall continue. But Lordship may, if so comments, kindly adds one line that with regard to appointment, Lordship, the 1940, because I could not lay a hand on other than this judgment.
Here it has been said that you have to supply 3 names, from that it will be
Yes,
appointed.
I am not opposing that. I am just asking Lordship for a clarification on that point, that this will be then, Lordship, this is a judgment which can be used in future cases also, because Lordship, the difficulty is I could not find any judgments either of the
Let
Supreme
it remain
Court.
not in this matter. Yes, next.
I'm great.
Yes.
My application, my lord.
Yes.
Petitioners filed title suit for declaration and mandatory.
What is the miss case for?
Miss case is for Order 9, Rule 9.
Order 9, Rule 9.
Miss case registered in the year 2011, my lord. Along with Section 5 application allowed by the Shialda 4th Civil Judge Junior Division. And after that, case was transferred to Barakpur Court. And there, the record was untraced since long.
What happened on 1st of August 2026?
First was no order was
This
passed,
application
my lord.
under Article 227. Yes.
Lord, I am the defendant petitioner.
Yes.
My application under Order 6, Rule 17, seeking amendment of the plaint, was rejected by the learned court below. On the ground, my lord, the facts, my lord, seek to be incorporated are out of matrimonial acrimony. My lord, may kindly seek, my lord, the impugned order. My lord, out of matrimonial acrimony. So, my lord, it is not. Now, my lord, the facts.
Where is the plaint?
Yes. My lord, kindly turns to, my lord, page 34. I'm sorry, may I stand corrected? 24. Prayer would be at page 29. Now, my lord, if your lordship permit, my lord's kind wisdom, may I just tell you, lordship, the facts? My lord, I am, my lord, arrayed as a defendant in a suit. Now, my lord, the plaintiff, my lord, happens to be a surrogate mother of, my lord, the 2 child of my deceased husband. Now, my lord, I am a legally married wife. Now, this son and daughter, along with their mother, who later, my lord, happened to be a concubine with my husband, they together filed a suit for declaration as well as permanent injunction against me. My lord, I filed a suit for, my lord, a partition against the 2 child of my father. My lord will find at page 62 my plaint. That is on a different court, my lord, on the valuation or senior division. Now, my lord, in my written statement, my lord will find at
My lord, it starts from page 36 onwards. My lord, relevant at paragraph 14 at page 39. I said, my lord, that how, my lord, this disputes are
39.
39, paragraph 14, which I seek to amend. Well, is only, my lord, to give, my lord, more.
Paragraph 14.
14, my lord. Page 39.
Yes.
I have already stated, my lord, only to give, and also, my lord, after filing of the written statement, my lord, my lord, my partition suit, I said that in 2024, my lord, I visited the property in order to have an amicable partition. There were certain disputes, my lord, arose between the parties. I, my lord, complained before the police station. There were certain things, my lord.
No, that is the suit. That is in the suit for partition.
Partition.
This is not a suit for partition.
This is a suit for declaration and injunction.
Yes.
Now, my lord, what I, my lord, in paragraph 14, my lord, kindly see.
Yes.
That the true fact of the suit is that the defendant is the widow of.
Where is the amendment?
Yes. Page 69. My lord, the schedule, my lord, will find at 71. The learned trial judge, my lord, proceeded that this is a matrimonial acrimony. That is a fact, my lord, because my lord, the plaintiff number 1, who happens to be opposite part number 1, she has no right, title, interest in the property. How could she have a declaration? That is what, my lord, I intended to say over here. This is judgment, my lord, for purpose of elucidation of the proper dispute and to adjudicate the real controversy. And after I filed the written statement, my lord, also between
So you wanted to replace certain facts in the plain by substituting certain portions.
Exactly. What is already there in paragraph 40. And also the facts, my lord, which happened after 2021. That is after filing of the written statement there. Because I filed a partition suit in 2024. The necessity to file a partition suit, my lord, how, my lord, it occurred to me, my lord, which my lord, required me to file. I only, my lord, stated those facts for the purpose of proper adjudication of this suit. And these facts has to be brought on record. Paragraph 14, my lord, cannot be, my lord, read as anonymous. I have stated, my lord, kindly see at page 40 of the said paragraph 14. Just the next page.
Page
40. Paragraph 14, my lord, second part. My lord, scene 39.
Yes.
Last few portions. The plaintiff filed this suit being represented herself legal heirs of the husband, namely Dilip, of the defendant Dilip Shah. 6 line from the top. Below, my lord. Lordship has found, my lord.
Yes, yes.
This is how, my lord, she cannot claim. That is what I said, my lord. And in paragraph 14, my lord, none of the facts, my lord, are something alien to this. And, my lord, in page 40, just, my lord, above there, I also said that what are the status of the two child. If my lord, continues paragraph 14 from page 39 onwards, I said so. Why, my lord, this plaintiff one happened to be a surrogate mother? Because
so all these facts have been stated. Where is the necessity for amendment?
No. But I have brought these facts also, my lord, filing of a partition suit.
Partition suit is neither here nor there.
No. And also to the nature that why she is not a legally married wife. Because I am the legally married wife. Those are the documents, my lord, that I intend to, my lord, bring on record.
Documents, is it necessary to be pleaded, Mr. Basu? Evidence is required to be pleaded.
My lord, correct, my lord, but only the facts. If my lord kindly comes to page 71, what I said, my lord, I said, my lord, the date of my marriage certificate. These are the things, my lord.
Anything more?
If my lord is not minded, my lord.
No, you can place. Yes.
My lord, kindly comes to. My lord, kindly comes to page 71.
Mr. Basu, in a suit for declaration of title and permanent injunction, so this factum of marriage, marital acrimony are necessary for the purpose of deciding.
Those factums,
at this stage, Mr. Basu, you are making these submissions.
These are factum are not necessary. Now, my lord, I am the legally married.
And you can delete some portions of the written statement, replace the same by something. Is it the law?
No, my
You
lord,
can do that. That's exactly what you are trying to do.
No, my lord, here, my lord,
The
what?
Honorable Supreme Court has replicated. You cannot withdraw the admissions. You can explain that. How can you replace, strike out some portions of the written statement, insert some portions?
No, my lord, that is.
It's a legal position in law.
My lord, I have understood. My lord, so far as those parties concerned, then my lord, kindly, my lord, may I
So
say
then
so?
that is your application.
Now, my lord, here, my lord, the learned judge, my lord, did not even deal that.
I
He
will
only-
supply the reasons.
No, that lordship 227 court can.
Yes.
Now, my lord, only one, my lord, indulgence, my lord. Kindly, my lord, permit me to file a proper application, if so, my lord, advice. Just to, my lord, not for the.
Mr. Basu, if you are entitled as per the law, you can file that. Because this liberty will be used in another way to try to overcome the proviso.
No, my lord,
That cannot be done.
No, my lord, will restrict me, my lord, to the extent that only for the purpose
If you are
of.
entitled to as per the law, you can file. No liberty is necessary for that. Ashun, this application under Article 227 Mr. Basu.
Yes, of course.
So it's your duty to point out to the court that evidence need not be pleaded. Liberty is dangerous, Mr. Basu.
It can be used in both ways.
Yes.
Very.
Next.
I am evening for petition on my lord. Malad, the opposite party and plaintiffs filed their title suit for declaration and injunction.
Yes.
Finally come to my lord, page 15, annexure P1.
Page?
There are, my lord, six, my lord, page 15, my lord. There are six, my lord, plaintiffs.
Yes.
And my lord,
What is the impugned order?
my lord, impugned order, my lord, dated
18th of May.
18th May 2026. Whereby, my lord, the matter has been fixed, my lord, expertly. Though, my lord, after appearance, I filed the written statement, and that is also on record. But in spite of that, matter has been fixed expertly against the petitioners. My lord, there are 9. Praying for filing written statement that was rejected. So, my
Have you
lord,
filed any application for vacating the ex parte hearing?
my lord, that I came to know, my lord, after obtaining the certified copy, my lord.
Then you have to take steps for vacating before the trial court.
My lord, date is fixed on, my lord, 20th, tomorrow, my lord.
That's neither
For
here
ex
nor
parte
there.
hearing, my lord,
You
kindly
have to
stay
file
there,
an
my lord, I'll take step there, my lord.
The petitioner on that, the second defendant number 6 appeared, paid for time. When did you file your written statement?
Yes, my lord, that is in
Which
recorded,
date?
my lord, kindly see order number 9.
Order
Dated,
number
my lord, 1st
9.
December 2023. Prayer is allowed. Defendant number 1 to 5 and 8
Along with
appeared.
petition for written statement. When did you file?
My lord, that is 1st December 2023. That is written in the lower portion, my lord. Page, my lord, 62. Kindly see page 62. WS file for defendant 1 to 5.
Did you appear on that date?
Yes, my lord. I appeared and also my lord, filed the written statement on the date of appearance. That written statement also I have annexed, my lord, P2.
The learned advocate appearing for the
But in this case, the petitioner before your lordship being a husband may file a miss case under the Guardians and Wards Act, my lord. My lord, on 1/2/2025, he filed an application under 12(1) for interim visitations, my lord. My lord, when the date was fixed for my lord hearing of 12(1), my lord, on that very day, that is at page, my lord, 35, the wife opposite party filed a petition, maintainability petition of the original miss case, my lord. My lord, that's why my lord 12(1) was my lord postponed. My lord, on my lord 30th of 6/6/2026, on 6/6/2026, since they have filed an application for maintainability of main case, my lord, the case could not be taken up, my lord. My lord, if your lordship kindly takes pin to the my lord page 35 once, my lord, your lordship will find that 4/7/2026 for hearing of the petition dated 6/6/2026, then my lord kindly comes to the impugned order, my lord.
Yes.
On 31st of July 2026, their maintainability petition has been, my lord, rejected. My lord, I am on that, my lord. My lord, then my lord kindly comes to the, my lord, the ordering portion. The petition dated 6/6/2026 stands rejected.
That is the maintainability petition.
Yes, maintainability petition. That has been rejected. It is in my favor.
Yes.
Next, my lord, 21st August 2026 for evidence. My lord, without fixing date of my lord 12(1), my lord, the next date has been fixed for my lord evidence of the main miss case, my lord. My lord, kindly comes to page 34 once. My lordship will find, my lord, everything.
Where is your application under 12(1)?
Yes, my lord. My lord, I have annexed. My lord, kindly comes to page, my lord. Just page 23.
The grievance of the petitioner is that delay your, that means you don't want the custody.
I want, my lord.
Then, yes, call the next matter.
Lord, can it be taken up?
Please proceed with the miscellaneous case.
Yes. Lordship, item number 37, Mr. Krishnaraj Thakkar, he's appearing for the caveat, on caveat. Lordship, he's on his like short pass over, Lordship, just one matter.
Because I know, my lord, other matters. Let me start, my lord. Just give me, my lord, 5 minutes. Let me start.
Pass over.
My lord,
is it the same as the other matter?
No, my lord, the same judge.
Same counsel are the
same judge. And same, well, I don't want to, my lord, there's a defamation suit, my lord, which was filed, my lord, against, my lord, really, my lord, the plaintiff and the defendant one, my lord, are the main parties. My lord, according to the plaintiff, the defamatory material was sent to me. I'm defendant number 5. I'm, my lord, a listed company, my lord, a listed company.
You are the defendant number 5.
I'm the defendant number 5.
Yes.
So, my lord, after the suit was filed, my lord, the ad interim order, my lord, was refused. Then, my lord, they entered into a settlement. The plaintiff and the defendant one entered into a settlement. This was, my lord, on 4th November 2025. 4th December 2025. Then, my lord, I made an application saying, my lord, that I am really not a necessary or proper party because I was the recipient of, my lord, the material, my lord, defamatory material. That application, my lord, is pending. On, my lord, 13 July, and, my lord, I appeared, my lord, entered appearance, my lord, on 6th November 2025. On 13 July, the learned judge, my lord, before that notice was issued on my application, my lord, on 6th November, on 13 July, which is, my lord, the impugned order, the learned judge, my lord, ignoring that, my lord, there was a settlement and dismissed my petition, saying that I'm not a necessary party, and, my lord, directed my and closed the right for me to file, my lord, any written statement. Along with other defendants, I'm also, my lord, one of them. My lord, with great respect, my lord, why, my lord? So today, my lord, and on the ground that I've not, my lord, filed, my lord, board resolution, power of attorney, and, my lord, there is no authority, my lord, which all are, my lord, part of, my lord, the records of, my lord, the court. Kindly, my lord, come, my lord, to the impugned order. And sorry, my lord, before that, I forgot to mention something. On
What was the application filed?
My lord, application, my lord, will find at page 165. And they had also, my lord, given
That is the application filed by you.
Filed by me. And they had also given release
Under
letters.
1 Rule 10.
Yes.
So for striking out your name.
Yes. Well, that's at page 164 it starts.
164.
Yes. And at 160,
No, this is 151, not Order 1 Rule 10.
No, Malad, 151, Malad. Saying, Malad, that I'm not, Malad, necessary, 170.
All right, so in form it is Order 1 Rule 10.
In form, Malad, it is 170.
Yes, for deleting or expunging the name from the array of parties.
Yes.
Now,
and Malad, just before that, kindly, Malad, look at, Malad, the release letters which I have given in connection with the suit, page 182.
What is 182?
Malad, these are release letters, Malad, by the plaintiff to say that, Malad, they are not going to proceed against us because in terms of the settlement, they were supposed to, Malad, take steps. So they have taken, Malad, some steps, recalled some, Malad, withdrawn some of the suits, given us release letters. Can you look at this?
This is, what is the name of the defendant number 5?
Malad, Tech Mahindra Limited.
So it has been addressed to you?
Yes.
185.
182. It's 182.
Sorry, 182. Sorry.
The Board of Directors, Tech Mahindra Limited, Gateway Buildings and such, withdrawal of correspondence in relation to Calcutta Investment Company Limited, and of Bonanza Trading and of such, Khatan and Mr. Negri. Dear sirs, we refer to the various points received by you from us as on the date of this letter, collectively referred to as correspondence. In the point we have raised certain objections, statements sought clarification in relation to Calcutta Investment Company Limited and of Bonanza Trading Limited and of such. Upon further consideration and in view of washing of charge sheet number 62 of 2003, four issues stand resolved and nothing stands for consideration. We hereby expressly and unconditionally irrevocably withdraw the objection and statement made by us in correspondence in their entirety. We hereby agree, confirm, and undertake that we shall not hereafter raise any further objections, complaints, statements, or claims with regard to charge sheet number sunset, respect of Calcutta Industry Company, one of the trading, sunset, whether directly and going forward, let me treat as full and withdrawal of the objections in the following documents.
These documents are not part of the trial court records, perhaps. This document which my learned friend is reading is not part of the trial court records, perhaps.
It's not part of the trial court.
These are release letters which you have issued.
These are not part of trial court records. I'm on part of trial court records.
Part of the trial court's record.
But I have not given an opportunity.
Maybe.
My application was pending.
No, it's only for hearing of
Very
his
well, Malad.
application.
Kindly, Malad, come back to the application.
Malad, documents beyond trial court records can't be looked into for the
No,
first
but these
stage
are,
here.
Malad, my application was pending. Your my right
Not
to
part of
file
his
application was closed.
No, only one thing.
No.
Mr. Thakkar.
Yes, ma'am.
He filed an application under Order 1 Rule 10.
Yes, my lord.
For striking out his name from the array of parties for ABCD reasons.
Yes, my lord.
So that could have been allowed or rejected.
Yes.
So here the
Order impugned,
the-
kindly have.
yes, the learned trial judge has for petition for recording service such and such, considering the above, are declared ex parte in view of the foregoing written statement of the 1-5 have been closed, appearance and objections declared, 1 shall proceed to hearing without any written objection to other cause. What is this?
My lord,
On an application under order 1 rule 10,
no.
where is the finding, whether it's allowed or it's rejected? What's the ground?
My lord, my application was there to close his right to file because he has not filed.
Mr. Thakkar, good, bad, indifferent, it may be a frivolous application which Mr. Banerjee's client.
No, deletion of, my lord, kindly see why. My lord,
Deletion, he does not have a right to be deleted. He may remain. Where is the finding that he is not deleted?
no, the application was dismissed because there was no wakalatnama. I'm
don't
sorry,
say
there was a
that.
wakalatnama by the
177.
power of attorney.
That's also factually, my lord.
No,
on record wrong.
no, 1 minute.
Mr. Banerjee submits that these were part of the records. Please check that.
My lord, we have checked.
There
No,
cannot be any
okay.
dispute on this factual
No,
aspect.
so my lord, if there is a wrong recording in the order,
My lord,
with the
kindly look at
greatest
this.
of respect, it has to be corrected by the trial court. Whether there is a wakalatnama there or not, it has to be corrected by the trial.
Disclosed it. It's there. Well, this is the information slip. And I've disclosed. At 177, my lord will find that. 176, 177, 178.
Yes, yes.
This I have
The
not seen.
information slip. Mr.
This I
Thakkar,
have
this
not
is the
seen.
information slip.
I've given him a copy, my lord.
Please see, these were part of the records.
No, this is Reliance Industry. This is Tech Mahindra we are doing. Why?
5, Mr. Thakkar, please. If number 5.
5, 6, 7. File photocopies of the power of attorney along with wakalatnama separately. 5, 6, 7 separately.
I have disclosed it, my lord. It's on record here also.
Mr. Thakkar, please take instructions. If these are on record,
My lord,
on
kindly
this
stay
ground,
the
it
order,
could
my
not
lord. This,
happen.
my lord, I'm sorry to say, my lord, this is happening, my lord, with. I don't want to make, my lord, any further submission. I will make him, my lord, in the other matter.
Because there cannot be dispute on this factual aspect.
No, there cannot be a dispute whether it is
Mr.
there or not.
Banerjee has produced the information slip
Yes,
from the court that these were part of the records.
yes.
And
I can grant you an opportunity to
I'll take
take
inspection.
instruction. I'm keeping
My lord,
tomorrow.
kindly, my lord,
Yes.
stay it, my lord. Kindly, my lord,
Tomorrow,
stay, my
Kindly
lord.
keep it tomorrow.
Tomorrow, my lord, I'm not there, my lord. Kindly stay the order, my lord. But so far, my lord, he doesn't, my lord. It's all on record.
My lord, even if it is
And it's
there,
there, and it's fixed
one
tomorrow.
minute, 1 minute. There's no question of staying, even if it is there. Let us proceed on the basis it is there. I see this. I will take instructions on this. There's no question of stay. Why I say this is, if it is there, all that he can have,
Then this order has to be set aside.
No,
Because
only-
on that ground itself.
my lord, only to
that
the,
was-
my lord, no, kindly bear with me. Only to the limited extent that of dismissal of his order 1 rule 10. Only to that limited extent.
Yes, yes, order
Only
1
to
rule
that,
10.
yes. I will take instructions on this. Mr. Banerjee is not there tomorrow, I understand. But if this document is there, if this is a genuine document, which I have no reason to doubt, only to the limited extent that is order 1 rule 10 application was dismissed.
File written statement. if it-
No, that is separate. My lord, whether he has a right
If,
to.
my lord, I
No,
get
no, no, no.
deleted, where's the question?
So he has not filed written statement.
Order 1 rule 10 to be decided.
That's all. Yes. If once order 1 rule 10 is
Yes,
decided,
kindly set aside the order.
no,
Order has to be set
not in
aside.
its entirety.
Order
Cannot
1 rule 10 portion has to be set aside.
Only.
If
I
the order
follow.
1 rule 10
I
set
follow.
aside, closing my right, my lord, to file, my lord, a written statement.
That he has
will
not done within the statutory time. He has to take out an application there. No. My lord, if he has chosen
there
not
are
to
two
file.
things. One is, if you have not filed your written statement within the stipulated time frame,
My lord,
your right to file written
my
statement.
lord, this is not commercial, this is a suit. I can, my lord,
Regular
always, my lord, ask for
Any
extension
time.
of time, my lord,
Yes,
file
yes.
statement. And not only that, I'll show, my lord, the matter settled.
But
No,
that's
no.
My lord, in terms
till
of the
date-
settlement, my lord, in terms of the settlement, they have to withdraw the suit as well.
that Mr. Banerjee, you can
No settlement with Mahindra.
you can also pay for extension of time to file written statement.
Yes.
Yes,
That's a
that portion
different-
can't stay.
That's a different thing
That
altogether.
portion can't stay.
No, he has
First
so
of all, my lord,
cause
my
why
order
he has
1
not
rule 10
filed.
No,
He
first
has to
order
show
1 rule 10
cause,
is
he has to
dismissed.
take out an application.
Wrong premise, completely wrong premise. And then says
Really?
that, no, I will not hear you because of this, and then my lord, closes my right to file. Even defendant number 1, my lord, has preferred a civil division petition.
My lord, we are on this application. I'm not talking
Order
about
1
any
rule-
other application.
Defendant number 1 has also been, my lord, allowed, my lord, so far as, my lord, to
That
file
is a
this
separate
statement
matter
is concerned.
altogether.
No, no, not separate matter.
Of
He's
course,
also
it
one of
is
the
a separate
defendants.
matter altogether.
I have a better case.
You may be.
Same suit.
That order was on consent. I'm not consenting here. He has to file an application to show cause. Very well, let
But I
us
wanted
argue
to be
on the
satisfied.
basis it is there.
No, Mr. Banerjee, only one thing.
Yes, ma'am.
With regard to closure of your right to file written statement, the learned trial judge has recorded that you have entered appearance on 6th of November.
Yes.
You are 5. 6th of November
Yes.
2025.
Yes.
But till date, that's till 13th of July 2026, you have not filed your written statement.
No.
Yes.
So the statutory period expired.
Yes.
So you may have a right to pay for extension.
Yes.
So unless and until that is done, so your right that has been closed.
Three
You can-
submissions. Well, 3 submissions. First, I made an application saying, my lord, I'm not a necessary or proper party because, my lord, I'm only recipient of, my lord, the alleged defamatory, my lord, material which they say. Second, my lord, there is already a settlement, my lord, between the plaintiff and the defendant number 1, in terms of which, my lord, he is to withdraw, my lord, this suit. This suit has to be withdrawn. That's second.
Yes.
Third, my lord, if the order 1, my lord, order 1 rule 10 is, my lord, set aside, then quite naturally, my lord, depending on how it decides or what it decides, then, my lord, it will be a question, my lord, whether I have to file written statement or not. It can't be, my lord, now Mr. Thakkar will say, no, his petition will be dismissed.
No, I don't say it has to be heard.
So, my lord, kindly set aside the whole order, my lord.
It cannot be the whole order.
My lord, kindly
Let us
set aside the
consider
whole
the
order
lobby.
because
Let
that
us
is the
proceed on the
basis.
basis
That
that
is the
it's there.
basis on which, my lord, my right has been closed. Can you look at, my lord, the 13th July?
কি আছে এটা খবর না?
Kindly see, my lord. My entering appearance, my lord, has been ignored. And he's given me release letters, my lord, while after the suit has been filed. And these are, my lord, all, my lord.
No.
And to place the release letters on record, we didn't have the opportunity. And, my lord, I have given the orders. My lord, first was, kindly see, my lord, how it's progressed. 12th March, 6th November, my lord, I enter appearance. Notice is issued, my lord, on my order 1, rule 10. Objection in different areas. What objection is written?
When did you file that application under order 1 rule 10 or 151?
Page 181.
When? What is the date?
My lord, 6th November 2025. Can you look at the order, my lord?
6th November 2025.
Yes, my lord. Page 181.
That is the date when you appeared.
Yes. And, my lord, also directions were given, my lord, I think, my lord, for them to file written objection. No, বলা নেই, কিছু বলা নেই। And, my lord, the settlement was, my lord, on 4th November 2025, 4th December.
When the summons was served?
My lord, about, my lord, September, my lord, 5th September, my lord, 3rd September, my lord, 2025. 5th September.
Yes, Mr. Thakkar.
The section 151 application is at page 164.
182.
151 application was filed by D5.
Yes, that my lord has seen.
Caption is immaterial, Mr.
Very well.
Prayer,
Release
if
letter.
you kindly come to the form, it's really under order 1 rule 10.
Yes, under order 1 rule 10. Now, by-
captioned as 1 under 151.
very well, my lord, it is
It's at page 182. No, sorry.
164.
What?
Sorry.
Starts at 164.
Yes.
The reliefs are at
Where
170.
is 172? I had shown those release letters of 182, which my learned friend.
My
had
lord, we
issued,
are
but
not, I am not arguing on the merits. I'm not addressing your lordship on the merits of this application because it is yet to be decided on merits. It was decided on the short ground that the learned judge did not find the wakalatnama and power of attorney. I'm sorry, the wakalatnama was there according to the learned judge. Kindly come to page, kindly have the impugned order. The impugned order is a summary dismissal of the application on the ground that board.
Where are you reading? Where are you reading?
The impugned order, third at the bottom of the page, my lord. The first page.
First page.
First page, last paragraph. Seen the wakalatnama.
Yes, yes.
There is a wakalatnama.
Yes.
Seen the wakalatnama filed by all these defendants. No board resolution, letter of authority, power of attorney is found annexed thereto or filed on record in support thereof. In absence of proof, the appearance entered, objections, applications cannot be looked into. Accordingly, the order 1 rule 10 application is dismissed. Now my learned friend says, yes, it is there. Today, my lord, his right to file written statement stands closed by reason of passage of time. He chose to take out an order 1 rule 10 application. He elected to take an order 1 rule 10 application on the ground that he is not a necessary party, proper party, whatever. He chose not to file his written statement. Learned judge, with the greatest of respect, did no wrong in closing right to file written statement. Whether there was a wakalatnama or not, irrespective. Order 1 rule 10 application dismissed on the short ground that there is no board resolution or power of attorney. Now this document shows it is there. May I just trouble your lordship once? We have not had chance. It's slightly unusual because I find that this application has not been verified by the gentleman whose board resolution power of attorney annexed here. This revisional application.
This revisional application?
Yes, this is by somebody else. Kindly see. So I don't know, my lord, whether that this new gentleman who's filed this application before your lordship is also supported. Kindly see, it is here by one Sudhar Kompalli at page 27. Whereas the board resolution, power of attorney, all that is Sudhar Kompalli, your lordship sees page 27 has affirmed the revisional application. Slightly digressing, my lord. 27. Now your lordship sees the board resolution, power of attorney, which was filed before the lower court, which is annexed here, allegedly filed before the lower court. Annexure D is by one Rahul Sharma.
Page.
Now 176, 177, and the power of attorney is given at 178 to one gentleman called Rahul Sharma at 179. In the court below. Once and now.
Authority. He also has authority.
So Sudhar Kompalli, my lord, I don't know whether your lordship's application is supported by a power of attorney and board resolution. That's all that I'm saying. Your lordship will be satisfied.
This is the best point.
Your lordship will be satisfied because now these are.
No, power of attorney is there, last page. I don't know whether you have.
No, not in my supply copy. That is why. My supply copy does not.
In the copy, you can verify from the.
Sudhar Kompalli's power of attorney is there.
Please check up.
Because my ends with the, my lord.
Sir Banerjee, that should have been supplied to him also.
My lord, it should have been.
I'm sorry, my lord, I'm just.
After the certified copy.
I'm sorry. Because mine ends with the certified copy. Yes. This is.
So he has the authority. That has been. Mr. Banerjee, ask your advocate on record.
We will give a copy
of that.
Yes. He has the authority. Now, my lord, order 1 rule 10 by the impugned order. Order 1 rule 10 is dismissed for want of authority. Now, this document which I now see, it appears that it was there. So to that extent, this order can go, the order 1 rule 10 application can be heard. But not for closing his right to file written statement because that part cannot be interfered with. That has happened as a consequence of his not filing written statement. If, like Mr. Banerjee rightly said, he elected to file an order 1 rule 10. So I don't want to file a written statement. If I'm expunged from the record, I don't need to file a written. If his order 1 rule 10 fails, for whatever reasons, either it succeeds or it fails. If it succeeds, no question of filing written statement. If it fails, he will show cause. He will show cause. It's not a commercial suit. It's not that his right is foreclosed, but he has to show cause, and that is a separate proceeding altogether. That has nothing to do with his dismissal of order 1 rule 10. His order 1 rule 10 on the short ground that he is not competent person to file on behalf of the company because it's a company. Now the document, now this report shows it is there. We go by this report. Since Mr. Banerjee is in difficulty today, tomorrow, I don't want to hold him up or hold up the matter. I go by the genuineness of this document. This document shows it is there. So all that, in my respectful submission, only the in part of the impugned order, to the extent that is order 1 rule 10 is dismissed, can be set aside. With the greatest of respect. Closure of written statement, right to file written statement is by virtue of the operation of law. For that, his application was not there. That don't put me on the undefended board. We make applications before this court when we file an order 7 rule 11 that kindly do not transfer this suit to the undefended board. That is not the case. He has not taken out any application. His order 1 rule 10 doesn't say or doesn't have an interim relief that till this application is decided, kindly give me an injunction not to proceed in the undefended board or do not place me as close my right to file written statement. He has not moved any such application.
172, kindly look at the prayers.
Please give me a minute.
My lord, I'll take instructions on this, my lord. Because kindly see this document also, which is handed over to your lordship, my lord, this inspection report. I need to take some instructions on this. Kindly have this document once, the inspection report.
Please give me a minute.
This must be a typo. कहाँ है इसका ऑर्डर क्या है?
Yes.
Now, my lord, this also I need to take. Kindly have this document once. Must be a typographical mistake. Kindly see this. This.
Information slip.
Yes, must be a typographical mistake. I don't know, but
What is the
people should have been more careful. Kindly see the serial number and date over there.
Yes.
11th August 2025. Must be a typographical. I don't know, but must be a typographical. We should have been more careful. No, the advocate who has filed it. I'm not saying anybody is responsible. I'm saying must be a typographical mistake since it's coming.
The seal, Mr. Thakkar, you will be finding seal is up to 2023.
Now, kindly come back to the order.
Kindly back to the points, my lord, I'm sure.
Order impugned.
No,
That's the original, my lord.
Yes,
That's the same date.
The
order date is the same in the original. Date is the same, 11th August 20.
What Mr. Thakkar is saying,
There's a
look at the
typographical.
top.
I said there's a typographical.
2025. That is what he is
I'm
saying.
saying it's a typographical. Kindly come back to the order impugned.
From Mr. Thakkar.
Kindly come back to it.
Not expected. You just followed a
See in the
higher,
as far as the order 1 rule 10 application is concerned, it is dismissed, not gone into considered on merits for want of proper authority. Now, since this document shows, on the basis of this document, I beseech your lordship, set aside that order, but record that this document has been filed, which would show that there is something there, that there's what the learned judge has not found. Ordinarily, I would have submitted, my lord, that if there is a mistake in a recording of a court, that the procedure prescribed in law is that you have to go back to the same court. That is what we've learned from A.R. Antule's case. We go back to the same court. There's an error in recording. It has to be corrected by the same court. This is
the fact on the documents shows that there is an error.
Yes, so that is why I said, my lord, but for this, I did not know of this. I had taken instructions that there is no such document there because I think in some other matter also this issue came up. My instructions were it's not there, but I proceed on what the court record says. My instructions I ignore. Now, on the basis of this document, and let us proceed on the basis that actually there was a power of attorney board resolution. All that can, my lord, with the greatest of respect, again I say, application under Order 1, Rule 10, read with 151 can be restored to the file. Because that is the only ground on which it has been dismissed. Learned judge has not gone into it. Now, admitted position is they filed a wakalatnama. They chose not to file a written statement because they were of the view that they have a right to be expunged for whatever be the reasons. So that is the election they made. They don't file a written statement. Order 1, Rule 10 can be filed at any stage of the proceeding. Even after filing written statement, I can come and say, please expunge me. Can be done, but they chose not to do that. They elected to not to file written statement, but file an application. Now, with the passage of time, their right to file written statement stands closed. The law provides the remedy as to how it is to be restored. Calling upon your lordship to set aside the entire order when there is no application. I would have understood if they had an application on that date to file their written statement also. There was no application made by them on that date showing cause as to why they could not file within the prescribed time or for extension of time to file written statement. And with the greatest of respect, the learned judge did no wrong in closing their right to file defense. Summons has been rightly served. Summons has been received. Party elects.
Yes, Mr. Banerjee, anything in reply?
My lord, 172, my lord, kindly have a look at page 172, my lord. My lord, it's part of, my lord, the order 1 rule 10, my lord, or 151.
172, yes.
That's the prayer. And stay of further proceedings in the instance suit till the disposal of the present happening, including filing of written by the defendant number 1.
Yes.
By defendant number 5.
Coming up for final hearing.
That prayer was also there.
No prayer in the interim.
But to pass identity mode in terms of prayers above, what are you saying?
So it's come up for final hearing after 3
Maybe.
months or 8 months, whenever you did not secure an ad interim order in terms of prayer.
In a suit, my lord, which is filed, I am really, my lord, not the main contesting defendant. In a suit, my lord, where it is settled on 4th December. In a
But
suit,
I
my
don't
lord,
know, he's not party to the
Well, excuse
settlement,
me,
and the
Mr.
settlement is
Mr.
not
Thakkar,
on
I'm
record.
with your submission. And in a suit where, my lord, they have themselves given us release letters, where, my lord, I filed this kind of application with a stay, my lord, to file a written statement. My lord, it is dismissed and then says time to file written statement is closed. Right to file written statement is closed. And my learned friend says, no, don't set aside the order. Just set aside order 1 rule 10. And, my lord, then again, what will happen if order 1 rule 10? Today, my lord, if this order stands, if I win, then also, my lord, this order will be binding. That I cannot file a written statement. Or, my lord, if I make an application for asking,
will allow.
if I ask for an application, make an application saying now you extend it since you have rejected order 1, rule 10. Then also, my lord, this order will stand. Saying that no, you cannot file because it's been affirmed by the revisional court and only this portion of the order was set aside. So the order has to go, my lord. After that, my lord, if I succeed, fail, if I fail, my lord, then I'll make an application saying that I failed. I may not accept your order. I may accept that order. I will have cause to show.
My lord, before lordship passes, my lord, an order, I mentioned this matter, my lord, 86 in the morning. This was at my instance, my lord. Reliance has filed another, my lord. Same, my lord, circumstances. My lord, lordship wanted me to, my lord, give them the letter of authority which I gave, and I also have the original.
My lord, kindly pass an order in this, then take up 86 immediately after that.
My lord, I have, my lord, an information.
Please wait.
Let this order be made.
Otherwise, I will be mixing the facts.
Yes, let this order be made. My lord, your lordship has heard us. This application, my lord, was fine. Application is made in November.
6. I am defendant 6.
This application 86 টা document.
Document though.
I come after 5.
Yes, yes, of course. I thought your lordship was rising.
His submission is, my lord, it's absolutely similar circumstances, my lord. Kindly sees the order, my lord. Lordship has already seen. It talks about, my lord, the
Also,
respondent.
the date has been shifted to after 7.
So, my lord, the order, as a lordship has clarified, it is against only 5th defendant, the benefit which lordship gave to Mr. Banerjee's client. So, naturally, I don't have that benefit. I am only requesting your lordship to, my lord, give me the same benefit.
Who are you? 6.
I am defendant number 6. I filed the application under, again, titled as 151, but prayer order 1 rule 10.
Copy
It's
paste
section
petition.
No, it's section 151. my
Copy
lord,
paste
moment-
petition.
No, my lord. 3 defendants were, my lord, taking same steps.
No, Mr. Thakur, what is your objection to this? You said power of attorney. What is
My lord,
there?
my lord, I don't know that inspection, if it is there in that, this case also.
5, 6, and 7, I think.
My lord, this is a different document. This is not the same document. This
is the document which I have obtained after the hearing. Lordship told me to give them a letter of authority. I took this information slip from the court below. And this is the document which possibly Mr. Banerjee was also relying a copy.
No, this.
So it talks
that
about 5,
document,
6,
this
and 7.
Yes, it's the same thing. Same mistake in the date.
Left hand side, same mistake. Right hand side, same correction, my lord.
Yes, what do you say?
My lord, kindly have the power of attorney which was given to your lordship.
Yes, what happened? What
Kindly see what the power of
এটা দিয়ে
attorney.
দিন তো অরিজিনালটা দিয়ে দিন।
No, let this be kept on
sir,
record also, because copy be kept on record of this.
I'll give a
photocopy of
I'll
that.
give a
Original.
No, no, no.
I have a copy, my
photocopy.
lord. I have a
One to be
Give a
given.
copy to Mr.
Yes,
Thakur
I-
also. Though he has got a copy of
I showed
that.
him the original also, my lord, when the previous matter was on.
Yes, power of attorney. What is
No, my lord, one thing, this kindly have first this application once, which is
page?
My
page.
application is order 1 rule 10, not 151. It's 163, my lord. Starts at 161, it's 163. Title is Order 1, Rule 10. So not a copy paste, my lord.
No.
Corrected.
151, I do not know
Correct.
who has written Order 1, Rule 10
My lord, it's
by
there,
hand.
it's there in the lower court, my lord. It's there.
And is it page 21, please, my lord, of this application?
Page
21.
Yes.
The learned advocate who's certifying is certifying as director. On the left says certified, the director of the company duly authorized on behalf of the petitioner. The gentleman who's affirming is as constituted attorney. He's not the director who's affirming the application. This
Constituted attorney.
Yes, but kindly see the certificate on the left.
Duly authorized on
I
behalf
certified the director of company duly authorized on behalf of the petitioner on my present. I don't know.
Director of
Whatever.
the company duly authorized.
Now, can you see the power now? Have the power of attorney which was handed over to us, my lord. Can you have the power of attorney? It was filed in court, I'm told, my lord.
Filed in court.
I handed over in court, and then on your lordship.
Wanted me, and this, my lord, authority is in respect of the application which is filed in the, my lord, court below.
No, Mr. Thakkar, this is not in this record.
No, my learned friend has to hand over then.
Oh, copy do na.
Because it is not the power of, this was what was given to us. Saikot Chatterjee. No.
No, it 606, 606.
This was what was provided to us. And your lordship will also kindly take the trouble of seeing the power of attorney in this, because that
Yes,
is also
Saikot Chatterjee. In this revision application,
we
that
have
is
not
there.
been given copies again. Same.
I have it.
No,
I
no.
can wait here and
Service copy doesn't have it. I lord.
same mistake like the previous one, but
They're all the same.
and the one which I gave to Mr. Thakkar's, my lord, advocate on record on the other day, it's this one.
So this is the power of attorney which according to you is filed in the trial court.
Right.
Because it is not appended to the application. It's not appended to the application.
No, it's not. But it's there in the trial.
In this application, which is
revision application.
Yes.
Yes, it has been. It's
In
part
the
of-
original, it's there.
No, that may be for this filing this application, but
Yes.
not in filing the application before the trial court.
No,
I
but the
don't know.
information slip says it contains the
No,
power
it
of attorney.
says, but I'm only saying, unlike the other matter, the power of attorney was made part of the application itself. The power of attorney filed in the
But
law.
it has been filed in the records. Records.
As it is. Now, my lord, let us proceed that this is information. This is a power. Kindly have the power of attorney once. This is a suit for defamation. Your lordship has been told. Suit for defamation. Kindly see what the power of attorney is for. Now know ye all my presence as so-and-so, Rajneesh Jain. I, Rajneesh Jain, constituted attorney of Reliance, having its registered office at so-and-so as authorized representative, signatory of Reliance. Appoint Sri Saikot Chatterjee as, now kindly see, authorized representative or signatory of Reliance, and authorize him to do all or any of the following acts, deed, matters, things on behalf of the company, in the name of the company, in behalf of the company, connection with, now my lord, kindly see, connection with the company's business of designing, building, and or maintaining the physical and digital infrastructure, which includes EPC services and provision of telecommunication services along with the said business in the state of West Bengal. The power of attorney which is given is in connection with the said business.
No, but business.
That is the preamble of the document. I give somebody a power of attorney to enter into an agreement for sale. He goes and enters into a conveyance.
No, but it says paragraph 6.
Yes, I've seen.
To accept notice, service of summons, legal process, everything, written statement.
Yes, but kindly in connection with the EPC services.
If you have any objection, you can raise because that document is here. So the learned trial judge has rejected on the ground.
It's only on the short ground. Very well, my lord. Similar.
Has to
but
be, my lord. See.
The dates are similar.
Absolutely, everything same.
No, one minute.
Acha.
Only, my lord, summons.
ওই আগেরটা কি-
Well, kindly kindly for my satisfaction, kindly record my submission that this power of attorney does not authorize him to institute proceedings which are not connected with EPC business.
My lord, before lordship makes that observation, 96(6).
No, I'm not saying anything.
My lord, without an authority, it can be filed. That is what Supreme Court is saying. It can be ratified. Why is Mr.
I'm
Thakkar
recording
taking all
his
these points?
submission.
Yes.
যেখানে একটা আছে না, Mr. Thakkar's submission, শেষে একটা লাইন লিখে দেবেন, after going through the power of attorney, Mr. Thakkar submits that the same was not issued for the purpose of
For the limited
contesting
purpose.
the suit for defamation.
Yes. My lord, that inspection slip be kept on record.
Inspection slip to kept on record.
And copy of the power of attorney.
Power of attorney, it has been annexed here in the civil revision application.
That is a power of attorney for this civil revisioner, not the power of attorney. Yes, the power of attorney filed in the trial court. So
it's this.
That is not part of the civil revision record.
Taken on record একটা করে রাখবেন।
And the information slip also.
And the information slip also.
Information.
Grateful, my lord.
Thank you. Yes, next.
Grateful, man.
This was 86.
This was 86.
My lord, my 151 can be titled as Order 1 Rule 10.
ও একটা জিনিস যেখানে না সবকটা একটুখানি কারেকশন হবে, ওইখানে বলছে
You're appealing. I'm for the opposite party.
Yes.
Well, this is this. Only one thing that on the last occasion, Lordship has already observed that whether the receiver had filed any report before the court below or not, accounts in the court below or not, whether that is there or not.
That I believe, my lord, that has been filed. We have also applied for the.
What is the instruction?
That has been filed.
Necessary instructions with regard to such allegations. Yes. What is your submission?
My lord, that has been filed.
Show me, please give in the documents.
March 2021 থেকে till date not filed. কি document দেখাচ্ছে দেখি 17 মাস থেকে দেয়নি তো 17 মাস 2021 date of appointment of receiver you have to give it from that date. স্যার ওরা বলছে দেখি রিপোর্ট নিয়ে এসেছে কিসের রিপোর্ট তারপরে কিছু নাই করেনি কাউকে দেওয়া যায়
No 330 today, Mr. Basu.
And nowadays 330 is no meaning because I have retired. That's the reason.
This is the order.
Yeah.
Not the order where show those accounts that you have submitted. Please show it to Mr. Basu first.
No,
yes, very well, very well.
Receiver will submit.
Yes, yes.
Something for the receiver, mother, essentially
yes.
for the receiver to submit.
Contention is otherwise instructed to say up till now not a single document has been filed.
We have received a copy.
Show him the document that the receiver has filed that account.
Was directed to be deposited, no profit. No profit. Previously we had profit. Prior to appointment of receiver, we had a profit.
The locus itself is under challenge, my lord. That is something which he cannot.
Please show him that the accounts have been filed. Please show it to
These are
Mr.
the
Basu.
accounts which has been filed. My lord, this is the affidavit which has been affirmed.
By whom?
That is something which has been affirmed by the petitioner.
Well, this is affidavit in opposition on behalf of a party to this proceeding, not by the receiver.
Otherwise, I cannot have it. Otherwise, whatever has been
very well.
Then the the accounts have been filed by the receiver. Mr. Basu, please check up.
My condition is.
Because the receiver is not here. So if he has filed, he is producing that.
Can I take up the amendment? Very well. That's what I'm on, my lord. That is exactly what I'm on.
Yes.
Because the locus itself has to be assessed, my lord, at this juncture. My lord, I'll just indicate what is the case about.
Civil division কার লোক আছে কি বলছিস বাবা
আমি বলবো না দাদা তাই বলতে দাও Now, my lord, the issue over here is plaintiff appears to have filed this particular suit.
Who are you?
I'm the defendant, my lord, the owner of the premises, the hotel. Undisputedly the owner. Now, my lord, the issue over here is, in this present case, now, my lord, in this present case, the hotel, I'm being led by Mr. Mukherjee, my lord.
I can, but I cannot finish, Lord, within the 15 minutes that we have. But I can start, and Lord, I can give your Lordship the points here. Lord, if your Lordship kindly comes to Lord, the prayers in the plain first.
How much time you require?
I'll take half an hour.
Let him continue for half an hour overnight quarter tomorrow in the morning I will come to
Overnight quarter.
we had that concept previously nowadays quarter matters are going down
Overnight quarter.
Nowadays, we do not make patterns. Yes, yes.
Lord, your Lordship will kindly come.
Don't want to do it.
let us start my lord kindly see whether there is the ingredients of under order 40 or not that's the main thing
My endeavor is to show before your Lordship whether he is entitled to get an injunction or not.
Absolutely.
Based upon, Lord, what he has pleaded and, Lord, what he has prayed.
What is the impugned order? What is the order under challenge?
I'll come to that, Lord. I'll come to that. There are two revisions before your Lordship. Lord.
Two revisions.
Two revision applications.
Both filed by you.
Yes. Now, Lord, your Lordship will kindly come to, Lord, the prayers that have been made. I will file this.
Prayers in
the plaint, Lord, that is at page 36 of.
In which matter? In which matter?
The first matter, 3330.
Yes, page
36. 36.
36.
Lordship. But I am the defendant here in this suit. The gentleman whom Lord files the suit, Lord, he is claiming that Lord, there was first, Lord, an agreement which he termed as a MOU, and thereafter, Lord, there was a power of attorney, and Lord, he has been terminated as a manager of Lord this particular hotel. So, Lord, before
you claim to be the owner of the hotel.
I am the owner of the hotel.
Yes, you claim to be the owner of the
I
hotel.
claim I am acknowledged to be the owner of the hotel.
All right. And he is appointed as a manager by you.
He is my relation, my brother's son, who was initially, Lord, according to him, was appointed as a manager to look after. Then he says that I have given a power of attorney, which I indeed gave a power of attorney, but for the limited reason to look after, Lord, the litigations. And he says that there is an unregistered memorandum of understanding, which says that I have agreed to, Lord, sell the hotel to him for certain consideration. All these three documents, Lord, I'll show before your Lordship. But before that, kindly see what is the prayer. It is not a suit for specific performance. The plaintiff may be granted a decree of perpetual injunction against the defendant, restraining him from forcibly giving the legal effect and a further effect to the invalid and illegal deed of revocation dated 24/2018 and the letter of termination dated 25/4/2018. The revocation is of the power of attorney and the termination is, Lord, as a manager. And or taking any steps for forcibly removing the plaintiff from management and ostensible ownership of A scheduled property and entering possession therein, and mandatory injunction directing the defendant to execute a proper deed of sale in favor of the plaintiff in respect of A scheduled property on receipt of the balance sale consideration upon a declaration that the
specific performance in the form of mandatory injunction,
and without not paying, Lord, the court fees, and the valuation statement will speak about that. There is no specific performance asked for. Because the valuation is, Lord, valued at rupees 99. The valuation statement.
Declaratory suit and injunction.
Yes. Yes.
49.99. These are the two valuations.
And Asansol. Even here also, Lord, in Alipur
49.99. In some cases is 101.
No,
Yes.
So, my lord, upon a declaration that the alleged deed of revocation dated 20/4/2018 and the letter of termination dated 25/4/2018 are both wholly arbitrary, malafide, fraudulent, illegal, invalid, void, and of no legal effect. So, my lord, here we are, my lord, on 3 documents. Now, your lordship will kindly have a look into, my lord, the documents. Page 41 is the power of attorney. I'm sorry.
Now,
I'm
on
sorry. I'm
this,
sorry.
what happened? An application for injunction was filed.
But application for injunction was filed, and thereafter, my lord, the appeal court also passed an order, my lord.
Of injunction.
Yes.
Please show me the order.
My lord,
That's the
it was-
contest. Calcutta is
Yes.
not trial court, no, appeal court. Yes. Lord, your lordship will kindly come to my lord. No, এটা তো appeal court একটা. Sorry. हाँ, 116. 116. 116.
Trial court's order.
Trial court's order, my lord, it was at the contested stage.
Yes.
It was rejected. Then, my lord, the appeal court's order at page 129.
Considered and rejected.
Rejected. Then the appeal court's order at page 129.
129. Why certified copy you have not filed?
Additionally,
Oh, without certified copy, till date, Mr. Mukherjee, you have not filed the certified copy.
I have no idea, my lord. I think, my lord, it must have been filed.
nowadays,
I think it has been filed, my lord.
It has been filed.
I'll check the records, my lord. I'll check
All right.
the records.
Yes.
Check. Now, my lord, the appeal court was of the opinion that, my lord, the respondent defendant is restrained from giving effect to the deed of revocation dated 24 and the termination letter dated 25/4/18 or from interfering with the possession and management of the plaintiff appellant in respect of a scheduled property. So, my lord, here, Lord, all that I say is that your lordship will kindly see the nature of, Lord, the power of attorney, whether it is coupled with interest or not. If it is not, he is not entitled to an injunction. Now, Lord, if he says about the termination as, Lord, the manager of, Lord, the hotel, Lord, there cannot be specific performance against, Lord, the termination. Or, Lord, the court should not, Lord, pass an order, Lord, staying termination if it is a question of employment. So, Lord, here on the 2 score, my submission before your lordship is, Lord, that if your lordship looks into this document, similar the question of this, Lord, the MOU was never considered by the learned judge in the appeal court. And MOU was not, Lord, sought to be specifically enforced even in the suit.
there is no declaration also, sir.
So MOU not considered.
MOU was not, Lord, considered by the learned judge to be, Lord, a document which requires, Lord, the protection. It is only about, Lord, the revocation of the power of attorney and, Lord, the termination letter. So, Lord, kindly come to, Lord, the power of attorney first, page 47. This is a general power of attorney, only, Lord, entrusting, Lord, to look after, manage and control, and, Lord, the litigations. Page 48, Lord, to 51. These are all very general power of attorney. Contract Act,
69. Section 16.
Yes.
Then your lordship will kindly see कोई এটা কোথায় Lord, the power of attorney which stood revoked, your lordship will find at page 41. So this was the power of attorney, my lord, which was revoked.
41 or
Page
42?
41.
41.
Lordship. And this was also, my lord, notified in the newspaper. That is at page, my lord, 45.
You also sent a notice to.
Yes, there is also a notice that is all about the revocation.
Yes. And termination is at page 42.
Termination is at not page 42. These are all about not the revocation of the power of attorney. And not the termination of. Yes, that is the employment termination.
Page 42.
Page 42.
What is the finding of the appellate court on this?
But the appeal court, Lord, has kindly, Lord, have a look at Lord the para 20 at page, Lord, internal page, Lord 4. That is running page 131 of my Lord's brief.
Yes.
There's nothing, Lord, on the question about the propriety.
No, MOU was considered by the appellate court.
But he was, but not the MOU, not there was no relief paid on the MOU. I'll show the MOU. Your Lordship will kindly have a look at page 46.
Let me first go through that order of the appellate.
Lordship. বড্ড তাড়াতাড়ি প্রসিড করছি না দাঁড়াও, আর 2 মিনিট 2-3 মিনিট 2-3 মিনিট
Yes.
Your Lordship has looked into Lord para 23. The material on record prima facie established that the plaintiff has been in settled possession and management of the suit property since execution of the MOU dated 2014. The receipt and document produced evidencing renovation work, clearing of the debts and advances paid towards the property lent sufficient prima facie support to the case of the plaintiff that he has been complying with the terms of the said MOU. Such long and
So basically the finding was that MOU was acted upon by the parties.
He did not ask for any relief on the MOU. By way of
the
now,
appellate court proceeds on the basis that the MOU was acted upon by the parties.
now immediately that raises a question that if it is a possession given in part performance of the contract, kindly have a look into the nature of the contract. It is an unregistered document.
Page
46. And it was our specific case that this was not a piece of forgery.
Payment
46.
Page 46.
Yes.
this is your lordship will see, my lord, there are only 2 signatures in the bottom. And my lord, there are certain conditions which have been put in, and this is what he says to be, my lord, the MOU for sale of, my lord, the entire property. He doesn't ask for a specific performance on this. This is unregistered document. He cannot claim possession. He says that my suit is based upon revocation of the power of attorney, which I have shown before your lordship. He says that he cannot be terminated as a manager. It doesn't require a witness.
Forged document, any challenge anywhere? Any challenge anywhere? Forged document, any
I'll
complaint?
show. I'll show.
Yes.
It's not appearing.
I'll
আচ্ছা,
show.
বন্ধ করো, সাড়ে চারটে।
Yes. Yes.
No, my lord, can you don't? Let us come back. After 4:30, exhausted, everybody. Mind will not work.
Especially he's
40
traveling, my lord,
40
from
years.
Jalpaiguri.
No, that
Yesterday he was there.
Yesterday I come. No problem. After 4:30, mind cannot work. 40 years. Chal.
Come back tomorrow.
How much time it will take?
Another half an hour. May not be not that much, maybe a little less.
Outer limit.
But by now your lordship knows the contours of my argument, my lord. And my lord, in the other matter, my lord, there has been, my lord, appointment of a receiver, which was, my lord, also stayed by the appeal court. The trial court appointed a receiver, stayed by the appeal court, and thereafter, my lord, I am before your lordship.
That was
And
your
lordship
application
is
for
pleased to pass an interim order.
your application for appointment of a receiver.
Lordship.
My lord is adjourning is still
Tomorrow morning,
আমার কোনো অসুবিধা নেই। If my lord is otherwise busy, then my lord I will be praying for a leave to give a notice to the receiver.
No, that is not necessary. Your lordship is hearing the matter here.
Maybe.
It was
Maybe.
on an understanding, my lord, that your lordship fix the matter because I'll do the matter, my lord, finally.
Hearing. But an order passed by a court on the receiver and he is not complied with for 5 years, that court cannot satisfy.
Receiver that he has to satisfy.
Yes.
And whether the orders of the Mr. Mukherjee, the orders of the court, whether it has been complied with by an officer appointed by the court.
But I'll show before your lordship, my lord, how it has been.
Not.
How it has
Let him appear.
if there is
Who is
my lord,
the
this
receiver?
No, this is my lord, why I say this. He's creating a pressure by asking for appearance of the receiver here before your lordship. That is not a requirement.
Receiver and he cannot come.
No, he has been appointed by the court.
Receiver is an advocate.
Advocate.
Advocate practicing in Asansol.
So what? Our
Now he has been
was called in Bakura, appointed by the
He can also appoint through an advocate.
He is faulted.
Mr. Mukherjee, he can also appoint through an advocate. It's not necessary for
It is not necessary as of
well, according to me, necessary.
Please
Court order has
consider.
to be complied.
It's an allegation against a member of the legal fraternity. Please
the
consider that.
allegation is all about that he has not within the time given the accounts. I have documents to show before your lordship that what he has given. Ota kothay kalke dekhal.
Something has been deposited in court as a profit, which is directed to be deposited.
Look, this
If
that
there is a
this-
profit,
If there is a profit.
there is a
The
profit.
previous month there was a profit of 7 lakhs, but the following month there is no profit.
No, Mr. Basu, that cannot be gone into if
So I am asking, let him appear before my lord and let my lord be satisfied that the order has been complied with. Nothing more. I cannot ask your lordship to scrutinize what is the profit, not profit. But he has to, basic thing he has to comply with.
Mr. Basu, Mr.
I have come up with
Mukherjee
all
says
this.
that these accounts have been filed.
Let us
And this
see,
is
my
not
lord.
the evidence that we have done.
Have you seen that?
No, my lord is keeping on which date. Let me, can I? I'll call for the
And this is not the order passed by the trial court. Kindly have a look.
Hobe. Hobe.
kindly record be called.
And kindly
At
see.
my cost, special message.
Records call for
I will expedite.
nowadays,
I will expedite.
Mr. Basu, nowadays we are thinking of not calling for the records in appeals also.
Right, but here it's a case.
So we are,
no,
we are trying to,
The last
we are
order.
trying to, because this takes time.
No,
for that.
we will kindly allow me to put the person because tomorrow we will take steps to get it before my lord. And also the notice to run a deceiver.
No,
This is all
Mr.
about-
Basu, Mr. Mukherjee is saying it's been filed. Are you
Let
doubting
me
that?
check up. I am not,
Your counterpart is there.
The order is before
I
me.
am not blaming Mr. Mukherjee.
No.
Up till now, my lord, your lordship is too satisfied.
Kindly have a look into the order.
I
Trial court order recording that the receiver has put in the accounts.
Oh, that has been shown in the last topic.
Yes, it doesn't file. The court records that.
Correctly, what can you read that? Can you read that? What is filed? Which period?
September 2025 to July 2026.
Before, after, where? Where?
It's for the trial court to see not about the propriety. No, I'm not about that. Because I'm really shy about the tactics that you are trying to take by putting pressure on the receiver.
What receiver?
By asking him to appear before the High Court. Because
let him appear through virtual mode. Now it is available.
what will he say before this court? He has only
Find the records. That's all.
Merely by asking the receiver not to
Sir,
appear.
Mukherjee, I think that's necessary because he's a member of the legal profession. Since it's a serious allegation against the receiver.
Kindly see, Lord, what allegation he makes. And Lord, if he makes an
He
allegation.
can also appear through an advocate.
No, Lord, what he is trying to put pressure without making any allegation, he is saying kindly direct the receiver to appear. Lord, what he will come and say before your lordship?
Because this also says nothing.
So that is
from September 25
I said
to July 26.
Yes.
The receiver was directed to file quarterly accounts.
Accounts, bi-monthly accounts. And
Yes, that is by
From September 2025 to July 2026 in August. That means prima facie shows that he is not complying, Mr. Mukherjee.
Lord, I can show before your lordship, Lord, there are other orders.
Mr. Mukherjee, prima facie shows that he is not complying because quarterly accounts have been directed to be submitted. And he has submitted from September 2025 to July 2026.
Give me the notice. Let him appear through virtual mode.
Hard, Mr. Mukherjee.
But either I succeed or fail on the basis of what those are on record.
Ballot receivers shall appear.
The Friday.
$430, your lordship. My lord, your lordship was pleased to keep it at 4:30 today, my lord.
You mentioned that.
Yes, sir.
Yes. What is this?
Your lordship on the last occasion directed that the appeal should be, it's not really borne in the eye of law because we have not made the pre-deposit.
Yes.
But this from the RERA order, we
Yes.
filed an appeal before the RERA appellate authority.
Yes.
Your lordship was of the opinion that the appeal is not really matured for, because we have not made the deposit. So
Yes,
we
yes.
have yesterday made the deposit of the 30% as per the statute, my lord. That deposit, my lord, we have, your lordship kindly sees this, my lord.
So now the appellate authority
is not constituted because the chairperson is not there. If your lordship kindly permits me to place 3 orders, appeal filed within the statutory period of limitation. But one of the difficulties, my lord, the appellate authority is not there. Kindly, my lord, takes a look at
page
104, my lord. Kindly sees the date, my lord, 11th of June 2026. As there is no chairperson, so appeal could not be, hearing could not be taken.
1st of July it was fixed then?
Yeah, no, it is fixed on 12th of 1st July. Then next page, 1st July order, 30th June order, fixed on 11th of August. Then my lord kindly turns to 10th of August order at page 106.
22nd of September.
22nd of September, still there is nothing. So my predicament is the next date. Now your lordship would kindly have a look at the impugned order. This is before the trial court, my lord, which is the regulatory authority. The after, my lord, page 112, my lord. 10th of July, this is taken up.
So this is the execution.
This is really the execution. Or contempt, whichever way your lordship coins this, my lord. Penalty has been imposed for non-compliance of the order, which is already under appeal. So, my lord, my predicament is I am being condemned unheard.
Petition is directed to serve a
Lordship. Because if this order may be stayed, tomorrow he might take up and say, okay, new order. It kindly stays this proceeding, my lord. Otherwise,
Same order cannot be passed, Mr. Gupta, which has been stayed. What are you saying? You come up with an
appellate authorities.
come up with a can application if that order is passed. Yes. Your son's birthday, Mr. Gupta says he has not been invited. (151). He is appearing for the other side.
Wanting your lordship to invoke 151.
I have served intimating that I will mention that. Who is there? Then how can it be taken up in this way? 27th. 22nd. Item number?
আরে আছে রে ভাই হ্যাঁ কারেকশনটাতে এখনই
Know who is appearing, how can you inform them? Yes.
The learned advocate who is there before the trial court, that also I can do.
কারু একটা অরিজিনাল অ্যাফিডেভিট অফ সার্ভিস ফেলে গেছে, আমাদের নয়, অরিজিনাল আছে। এই মামলাটা দেখুন সিও
151 টা দিন তো।
আমাদের তো হয়ে গেছে।
Matter may be come up as to be mentioned, but your lordship says that you can mention always at the time when your lordship directed me to serve. I filed an application with a put-up application that it can be taken up. The learned judge kept in September without looking that my son's birthday is not on 22nd. I have given the information slip also to the division.
Could
Again, your lordship, caveat has been lodged. They have served upon the caveat.
Caveat was there.
Yes.
Then what, how can it be taken up?
Try my luck tomorrow.
What is the impugned order?
Tribunal rejected my application on order 711. Admittedly, not.
Order 711 rejected.
Yes.
So what? What is the mentality will be decided, Mr. Ghosh?
No, civil court has no jurisdiction.
So that will be decided in the, you have made your arguments in the suit with regard to that. Order 7, Rule 11, if everything is done, mentality has to be an issue in the suit. So there he will be raising. So that let the trial court decide. Because after Order 7, Rule 11, the suit proceeded. What were you doing so long? It's not within 1 month, not from
3 months, within 3 months.
Not from 29th of June. It's prior to that. So what were you doing?
But after remand, Lord, the same order has been passed. This court remanded the matter.
So if the suit has been
Earlier
hard,
order.
mentality, it's better, Mr. Ghosh, you try your luck.
Mentality is something not the jurisdiction because it has been schedule written that it is.
Yes, so you have raised that point in the hearing of the suit also. That will be decided. The suit may be dismissed on that.
It will not be done. I know.
One expeditious disposal is monthly cited number 70.
Monthly cited number
70.
17 70. When did you mention?
Yesterday I mentioned you didn't take it.
Yesterday you have mentioned. All right, wait. Let me